tender,
Ah.
and I was terminated from the tender. My lord, I shall satisfy your lordship. Rule provides 7 days clear notice is required. My lord, next week is the, my lord, the tender. I am debarred from taking participation on that tender. My lord, kindly, my lord.
Lordship,
No.
my matter was supposed to come on 26th June.
When is the next tender process?
My lord, next week. Date has not been declared, my lord. That is why, my lord, I am praying. I am extremely grateful to your lordship. Kindly accommodate, my lord.
8 तारीख को
Well, under a compelling circumstances, well, I am mentioning this matter.
yes.
Your lordship fixed this matter on 26th, but due to Muharram, my lord, the notification subsequently come. So automatically the procedure is that the matter will be listed on the next day, but the matter has not been listed.
Hey, Gaurav, why matter is being deleting from the list? Yesterday I got mentioning list. How it has been deleted? All complaining of deleting on the list. Why it has been, if the court has not said or the case is not called, why it is deleted? Why it is deleted? If the court holiday and date is fixed, it will come on the next day. Why the matter is deleting? Yesterday, all the mentioning about 15 matters I have seen. 26 it was fixed, but matters deleted. Who is deleting? Who has given the authority for delete? I have not given any authority. Neither I am telling anything for deletion of any of the matter. How it is deleting? You are taking your own decision. Tell me, give the reply. How it is deleting from the list? Huh? Why there is no answer? Why the matter is deleting from the list without my knowledge? What you want? Every day I have to issue the so-called notice to both of you. Sometimes you could not find the file. Sometimes your matter has been deleted. Sometimes which I have ordered for listing, you are not listing. Why it is deleted? No answer. You are not comparing the list. You are coming with the list to me. I am approving the list. Thereafter, you are not comparing the list. How it is deleted? Yes. Give.
My lord, may I be permitted? My lord,
Let me see. Why tomorrow?
Matter, my salary account has been under freeze.
Madam, thousands of case salary account, business account seized. If I will take, then you go to the Chief Justice and tell one court is to be open for only for the freezing of the account. I will see as per my diary. I will fix the date. Yes, next.
my lord, be pleased to mention. My lord, yesterday, my lord, item number 1, my lord was pleased to take up. My lord was very angry with us. My lord,
Not angry. You brought your senior had argued the 5 matters
my lord.
and give the impression that in all 5 matters on the forensic audit report are the same.
Yes, my
It
lord.
is argument.
Yes, my lord.
When I dictated the judgment, I find this audit report of the State Bank is different, audit report of the HDFC is different, audit report of Bank of India is different, audit report of another bank. And your which bank?
My lord, IDBI Bank. Yes.
IDBI Bank. There is no report you annex with the writ application,
My-
and you argue the total case on the basis of the forensic audit report, and forensic audit report is not in file. So what the court will do?
My lord, may
You
I?
have not taken the leave for filing the supplementary affidavit by enclosing the
My lord, we can.
audit report.
My lord, may I?
3 seniors have argued the matter.
Yes.
Then
My lord, may I assist, my lord?
I already passed an order. Whatever.
My lord, only for my lord, only one thing. My lord, for the IDBI Bank, the forensic audit report was not served upon us. There
That
is a
is not the
specific.
case.
My lord,
That is not the case.
my lord, there is in the reply, my lord, we had written that the audit report was not served upon us, and in the other banks, my lord,
That
the
is
audit
not
report.
the argument. Your argument was all the audit report are replica of same. But I find this SBI report is different, HDFC
My
is
lord-
different, something is
My
different.
lord,
Now
the
you're taking
SBI
another stand that that IDBI bank report has not been served.
My lord, may I only assist, my lord? My lord, in the SBI bank, the audit report was complete. In the other banks, the audit report was incomplete. But
that
my lord, it is the
that's not
same.
the argument.
My lord, it was indicated by Mr. Kaur. My lord, may I only, for your assistance, my lord, may I only, I have a,
Pass the judgment, it has been
my lord, for
uploaded.
the other banks, because it is
Correct.
indicated.
Other bank, you will get the judgment tomorrow or day after tomorrow, whatever it is.
My lord,
And with regard to yesterday matter, I already dictated in open court and I signed it. I think it is uploaded.
My lord will kindly takes this once, my lord, only once. My lord, I have prepared a comparative chart, my lord, of the different pages of the forensic audit report, which my lord was probably not finding in case of the other banks. My lord will
I
kindly.
find I already recorded. I have dictated my judgment. That's what I'm telling. Within this week or next, by the most probably this week you get the judgment.
My lord will kindly keep
Take-
this.
take, you
My
can
lord,
use
these two
my
matters,
My lord, the husband of the petitioner, my lord, the kidneys are failure. All formalities have been completed. The state government has not yet been releasing order for transplantation. The private respondent, the hospital also, doctor also written that.
have you know the English how to read and write? You know or not? You are the advocate. You know the read and write. Go through the cause title of the today's cause list. Today is the mentioning date. Then yes, call the list.
my lord, these two matters, my
Extension of interim order.
My lord.
Yesterday, the matter was mentioned also. The file is before your.
जी कौन सा हाँ yes
May I have a lordship, please, to mention only one matter. My lord has disposed of this application on 19/6. The order is not uploaded. They are have filed an application before the DRT where your lordship's order, would be necessary.
19 is not uploaded
19.
matter
I have given, it's WPA 13770 Vikas Katyal versus Punjab National Bank. It was disposed of on 19. I have checked CIS as well as it is not. Yes.
there is no within
Yeah,
24
yes,
hours,
I'm aware of my lord. Always in my lord's court, orders are uploaded, my lord. 13770 of 2024. On 19th.
okay see if it's see and report to me
No, so this is the extension. This is third time I mentioned in the file.
what extension
Today is the date, last date for the extension.
Kalki Sharat
No,
sir,
still
DRT
today.
ke मामले में
This is the third time I
uploaded.
mentioned in the
have
file.
you
has
mentioned
arrived
tomorrow
yesterday.
yesterday you mentioned
Yes.
ए आज का एक
22nd,
लिस्ट दी ना
29th and today.
सप्लीमेंट्री कौन सा है आज के एक दिया ना आज का
File has arrived.
जस्ट ए मिनट आज के एक दिया ना लिस्ट चैम्बर से आया सप्लीमेंट्री करने के लिए कहाँ है वो लिस्ट मेरा चैम्बर से लिस्ट नहीं आया सप्लीमेंट्री लिस्ट करने के लिए कलो सप्लीमेंट्री में डालो
Grateful.
My lord, these two matters, my lord, there are orders, my
yes
lord,
call the list
my lord, my lord.
who is appearing for the one
Well, item number 1, my lord.
Yes.
I am appearing for the respondent. My lord, the judgment has been passed on 22nd of April.
correct
My lord, this matter is wrongly appearing as item number 190 in the monthly list.
correct
My lord, that-
today also 190
190.
so you will not mention ये होते हमें जमीन ना दादा The matrix list has to be mentioned on the prayer made by the counsel for the petitioner. It is submitted that by an order.
My lord, I am appearing for the respondent, my lord. It is
Respondent. It is submitted by the land council appearing for the respondent and by on 22nd of April 2026. This court has already disposed of the matter. Dispose of the matter, but inadvertently matter is appearing in the list. In view of the above, the department is directed to delist the WPA number 19200 of 2022 with can 1 of 2026 from the list of this court and to record and to appropriately record in the website as disposed of.
I'm grateful to your lordship.
Next,
I am for the petitioner's lordship.
I am dismissing.
Lordship,
I am dismissing it.
lordship, please, lordship.
On open court, I have dictated the judgment order. Your senior has told that within an hour he will deposit the court fee. I inform him unless and until the court fee is not deposited, I will not sign the judgment. Till Monday, that about 3 days, the court has waited. You have not filed the court fee. I
Lordship,
am
please
dismissing.
kindly hear me for 1 minute.
The-
Lordship. Lordship, please, lordship, kindly hear me.
Sorry, this type of
Lordship, they are very
the
poor
matter
people,
was
lordship.
taken up
I am
for hearing.
praying for only 1 week, lordship.
The matter was taken up for hearing. Dash kar dena, huh?
Lordship, they are very, after the
This
matter,
court has dictated
I have-
the order.
lordship, they
disposing
are very
of
poor
such
people, lordship.
But
That's why he couldn't collect the
but-
money, lordship. I am praying for only 1 week, lordship.
By dictating the order, this
Lordship,
and
they are very poor people,
there are
lordship.
65 petitioners in the writ application, but the petitioner has only paid the court fee of one petitioner. The learned counsel for the petitioner has given an undertaking before this court that in course of that day he will deposit the court fee. But this court has waited about 4 days for payment of the court fee, but the court fee has not paid. Accordingly, WPA number 20570 of 2025 is dismissed.
Lordship, kindly give me to liberty to file a fresh petition.
Who is appearing for item number 3? Where is the mentioning list? Land Council for the petitioner has mentioned the matter on 25th of June 2026. For listing the matter as to be mentioned on the ground that he has instruction from the petitioner for withdrawal of the case. As per the submission, as per the mentioning list, the matter is listed today, but none appears on behalf of the petitioner. This court find that the as per the mentioning, the petitioner is not intending to proceed with the matter. Accordingly, WPA number 27140 of 2025 is dismissed as withdrawn.
Well, for the petitioner, my lord, I am, my instruction is to withdraw the matter because the grievance has been deleted.
The matter is assessed to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted the advocate on record of the petitioner has received the written instruction from the petitioner, wherein it is mentioned that the grievance of the petitioner has been settled by the authorities, and as such the petitioner is not intending to proceed with the matter and place of withdrawal of the writ application. In view of the submission made by the counsel for the petitioner and the written communication dated 18 June 2026, WPA number 9186 of 2026 is dismissed as withdrawn. Written instruction be kept with the record.
My lord, I am for the petitioner.
Yes.
In this matter, my lord, petitioner has supplied a material.
Why to be mentioned?
But I have mentioned for information.
Yes. Yes.
My lord, the petitioner has supplied material to the Indian Railway. And that the payment was made delay of 111 days. And as per the Act, MSMED Act, there are provisions for compensation in terms of 3 times of the current interest, compounding monthly. And I have given an calculation in the page 7 my petition, amount is 1,83,000. But that amount.
Who is which authority? There is a affidavit of service.
Just called me over the phone.
Which authority? Union of India? Railway?
South Central.
Who is appearing for the South Eastern Railway?
The junior was there 2 minutes ago.
So, though the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner, the petitioner has filed the affidavit of service showing the service of notice upon the respondents, but none appears on behalf of the respondent. For the interest of justice, the case is adjourned. The petition is directed to inform the next date of hearing to the respondents and to file a fresh affidavit of service on the next date fixed. It is made clear that on the date fixed, if none appears on behalf of the respondents, the matter will be taken up for hearing in the absence of the respondent. The matter on 15th and 15th under the heading adjourn motion within 10 matters. Urgent motion 15 July. Within 10. Next.
And although the matter has come up for extension of interim order, not mentioned at our instance, but it appears that there is a confusion in
Two matters.
according paragraphs 5 and 6 of the order, 5 and 7 of the order.
5 and 7. Matter
Our
is
ladyship was pleased to pass an interim order.
considering the said representative disposed of with
Yes.
the direction will be given opportunity of hearing.
Yes, and paragraph 7 says matter be placed before the regular bench. But we should take clarification from the honorable bench, of course. But not there's the confusion. It missed, it escaped our notice since it was for a period of 2 weeks. But we all reasonably understood that it is an interim order and we should come back before the regular bench.
Regarding connected matter, item number 11, most probably. These are all in respect of same group of companies. Now, your lordship kindly sees my instructions in respect of item number 11. The same
11, I am not appearing.
money company.
You're not there. 11?
No, I don't know.
Now, in this case, central government has already ordered for SFI investigation. Now, the investigation was ordered on 23rd of April 2026 under section 2121C. Now, they are asking.
Let it be taken up in presence of the learned counsel who is representing.
Same company, directors
Okay,
are different.
let me. The matter is listed to be mentioned on the prayer made by the counsel for the petition. In this matter, you are appearing.
No, I am not appearing in this matter. Let him give notice to the MOLJ.
Counsel for the petitioner for extension of interim order. ठीक है? Now, counsel for the petitioner submit that by an order the paragraph 7, paragraph 5 and paragraph 7 are the contradictory paragraph of the order dated 29 May 2026 are contradictory. He further submit that by the said order, the interim order extended till the interim order is still today, and he prays for extension of interim order. He further submit that he will mention the matter before the appropriate bench who has passed the order dated 29th of May 2026. In view of the above, the interim order dated 29th of May 2026 is extended till 23rd of July 2026 or until further order with the liberty to the petitioner to mention before the appropriate bench for clarification of the order dated 29th May 2026.
Well, let him have a notice to the MOLJ.
Give the notice.
We will do that. We have given or we said one thing.
Next.
7, we have already issued passport.
Well, I want to
Passport
withdraw.
authority is now working under high speed.
I received the instruction to withdraw.
Withdraw. The matter is listed to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted the petitioner has filed the present date application for grant of passport, but during pendency of the present date application, the passport authority has already issued the passport to the petitioner. Accordingly, petitioner is not intending to proceed with the matter further. In view of the submission made by the counsel for the petitioner and the written instruction, WPA number 12953 of 2026 is dismissed as withdrawn. Written instruction kept with the recorder. Next.
This arises out of regulation under the IBBI regulation. Lordship kindly takes a look at the regulation because I do not know whether the Lordship has already heard a matter on this regulation. Lordship takes a look. These are this is the utilities information utilities regulation. Lordship kindly comes to, well, here what they do is anyone who lends money and there's a default, they have to upload on this website, NESL's, National Election, Form C giving the default, etc. The Form C and the information is given then to the borrower, to the debtor. He has chance to dispute it. Pre-reminders, dispute given, after verification of the authentication, there is a Form D published, whether it is disputed or authenticated or deemed to be authenticated. And but this has implication on the basis of if there's an authentication of the debt without dispute, then on that basis proceedings can be filed before NCLT in other cases also. So this verification has assumed of much importance because of a recent amendment, especially of IBC. Now, what has happened here, Lordship kindly sees Rule 20 or Regulation 20, whatever. And Regulation 20, Sub-Regulation 1. And information utility. NESL is one of such information utilities. And information utilities shall accept information submitted by a user in Form C. Now, Form C lagana chahiye na. Lordship kindly, and then before filing an application to initiate, then 1A, before filing an application to initiate corporate insolvency resolution process under Section 7 or 9, as the case may be, the creditor shall file the information of default. That is in Form C, which is also annexed here, which is a part of the regulation. Lordship will find, I think, internal page 16 of this regulation. This Form C has to be uploaded by the creditor.
Form C.
At the bottom of this page.
Yes.
Details relating to creation of debt. Then next page. Important one is, say, serial number. No, default, yes. Serial number 51 onwards.
51
onwards. Serial number 51 onwards. Those after filling up various other. 51 is the tenor of debt, installment amount, rate of interest, and then 57 is the principal outstanding, amount overdue, etc., etc. Various details have to be furnished. Information security. Then 79 is very important.
Where it is to be published?
This is to be uploaded by the lender on the website of the information utility. Respondent number 1 is one such information utility, and there's only one, NESL. Now, they have to upload this as per Rule 20. As per Rule 20. An information utility shall accept information submitted by a user in Form C. This will take me to Rule 21. Upon receiving this information, Lordship will kindly see Rule 21. An information utility, Rule 21(1), an information utility shall expeditiously undertake the process of authentication and verification of information of default as soon as it is received. And 2, for the purpose of sub-regulation 1, that is verification authentication, the information utility shall deliver the information of default to the debtor seeking confirmation of the same within 7 days. Then B, remind at least 3 times. Remind the debtor at least 3 times for confirmation of information of default in case the debtor does not respond. Allow 7 days each time for the debtor to respond. Next, deliver the information, then C. Deliver the information of default or the reminder as the case may be to the debtor either by hand or by post, etc. Now, Lordship kindly comes to 3, sub-regulation 321.3. On completion of the process under sub-regulation 2, the information utility shall record the status of authentication of information of default as indicated in the following tables. So we are not concerned with table 1 in this case, we are concerned with table 2. So let me read proviso. Provided that in case of financial creditors, that is lenders, money lender in advance, which are banks included in the second schedule of the RBI, in this case, State Bank of India, the information utility will record the status of authentication of information as indicated in the table 2 below. Serial number 1, debtor confirms the information of default, or B, either or debtor does not respond even after 3 reminders, status of authentication is authenticated, color immaterial. And 2, debtor disputes the information of default, then it is disputed. Now, Lordship, kindly, before I place the proviso, kindly come to 21A. That is that is what the debtor has to do. Debtor has to, upon receiving this notice, what does the debtor do? 21A, sub-regulation 1, an information utility shall verify the key details, such as email address of the debtor, document showing proof of debt, latest acknowledgement of debt by the debtor, and proof of default before issuance of record of default in Form D. Record of default is in Form D, that's the final notice. Now, sub-regulation 2 is important. In case a debtor disputes a part of default amount or entire default amount, such debtor shall provide the reasons for such dispute and upload the evidence for the same. In case of financial creditors, which are banks included in the second schedule, an information utility shall issue a record of default with the status of authentication as disputed for the default amount for which evidence of dispute has been received and verified, and issue a record of default with the status of authentication as authenticated in respect of the balance default amount. Now, Lordship, Form D, that is at page 20. That is a record of default.
Record of default.
That is Form D.
Yes.
Upon getting this record of default, there are various civil consequences following this record of default. Now, in this case, my lord, I receive a notice on the 8th of April, on the 9th of April, which is at page 162. This is the first notice of the first notice which I receive under regulation 21. Under regulation 21. That is the first notice, then 21(2)A. This is 21(2)A notice. This is Devpara Tea Company. Let's see paragraph, second paragraph. Financial information has been submitted to NESL information utility as per particulars furnished below. As per submitted information, you are connected to the mentioned credit facility as a debtor. Particulars of information submitted. Submitter's name, State Bank of India. Information as on 31st March 2026. Information submitted on 8th April 2026. So 8th April, they submit the information which after getting this, we register ourselves and we download it. That is at page 173. That is the Form C. Page 173 is just below National E-Governance Services Limited. Record of financial information dash Form C. This is the Form C.
This page 162.
Yes.
162 has been given by the bank.
No, it has been given by the NECL. the
NSCL.
information utility
Correct.
is forwarded
NSCL.
to me on the,
NSCL uploaded this.
and NECL forwards that to me saying that the State Bank of India has submitted the information on 8th April.
Correct.
And the information submitted is in Form C, which is at page 190, is 173. Is 173. 173 is what State Bank uploads on 8th April, and then NESL, respondent number 1, forwards that to me on 9th April. Not forwards me, informs me, and I go to the website and check it.
Information submitted 8 April, forwarded by the NSCL to you
On 9th April. 9th April. And the information is page 173.
170.
That is Form C.
Correct.
And Lordship, see the first box, second row, submitted by State Bank of India, submitted date and time.
Correct.
8th April.
Correct.
So this is 8th April and submitted in Form C, and the amount, etc. is stated. That is the default which State Bank submits this information on 8th April, and NESL R1 forwards that to me on 9th April.
Correct.
Thereafter, 1 or 2 more reminders have come. Lordship, the last of the reminders is 3rd of May, page 187. 3rd of May, page 187. This is the second or third reminder, and thereafter we submit our Lordship. This is to bring to your attention that
On receipt of this, what you have done?
now I submitted my dispute.
Have you raised the dispute?
Yes.
Where is that?
That is at page 189. 189. Dispute with regard to the information you submitted by State Bank of India regarding the alleged debt and default. And Lordship, this will be evident from 191 NESL response to this. After receiving my disputes, NESL responds on 7th May 2026. 191.
When you have submitted this dispute?
I submitted this on 7th May, and 9th, I submitted my disputes on yes, Lordship, see that the second paragraph, same day. This is to bring to your attention page 191, second page.
189.
That is 7th May.
When you uploaded?
That is 7th May.
Where
that will be evident from 191. NESL itself says it received on 7th May. Okay, 191, second paragraph. Dear Deparati, then the next. This is to bring to your attention that the financial information of default submitted by State Bank of India has been disputed by Depara on 7th May.
Yes.
So I submit on 7th May. And authentication status disputed.
Yes.
But this is not. Thereafter, I get a mail from NESL that you submit particulars, saying that as of now,
you are disputed on 7th May.
On 7th May, and NESL
and you received on 9th
April.
9th April.
And NESL records.
But there is any time limit for submission?
Lordship, there are 3 reminders, and Lordship will see 191. In the box, authentication status is disputed.
Yeah, disputed.
So now, after this, NESL writes to us saying that you have to give particulars. That is 12th of May.
Evidence.
Evidence. That is page 192. But this is not the issue here. I'm just telling you. So this is going on. Logically, see, this is to bring to your attention that the proof of dispute uploaded by you during the authentication information submitted by State Bank against
is rejected.
In case of rejection, please note.
Yes.
The authentication status is reversed back to earlier status. You are requested to submit valid proof of evidence for dispute within the permitted window to complete the authentication process. In fact, we have got another mail on 20th of June after filing this writ petition that.
So now, what is the problem?
Now the problem is, while this is going on, they submitted on 8th of April. Suddenly a document emerges, 194. Page 194. Form D, September 25, Lordship kindly see 194. Authentication is happening now since April 2026. Their Form C is April 26. And now page 194.
Yes.
Form D.
Yes.
Record of default, Lordship will see Lordship J and K. Status, this is my State Bank of India, same State Bank of India, Devpara, that is A and C. Then J, status of authentication of default, authenticated, and K is the most important. Authentication completed on 20th September 2025, 9:17 in the morning. And now what has happened is they have gone in a proceeding and shown this, that they have already been NESL records shows from September 25, they are default authenticated Form D. Well, I am only challenging this. On 8th April is the Form C uploaded. Even if this is by mistake, this has to be undone immediately. Otherwise, there's
Yes.
Lordship sees the Form D submitted. Lordship sees a page 18 page
What is the date of 194?
194 date is not given. Lordship kindly sees K is the only
Yes,
indicated.
the authentication completed on 20th
For
September.
2025. So
Correct.
this doesn't have a date.
But
2025.
the initiation in April 94.
April
April
2006.
2006.
And the Form C also uploaded on 8th April 2026. Lordship, that
Then what has happened after this?
now after this we then immediately come to court. This has to be undone. Whatever verification is going on, I shall submit and I shall.
So after this 12th May, after rejection, 12th May 192.
Yes.
192,
Thereafter we have. Now thereafter we have this. Lordship, thereafter this is still going on. This will be evident, Lordship. This was after the writ petition we have received. Only a copy of that. 20. On 20, this is the 20th June, Lordship will see NESL, the second letter, subject NESL request for authentication of default. Now, Lordship will find this is still going on. That will be evident. Second page. কোথায় গেল? Death status is active. Lordship will see 1, 2, 3, the second page. In case you find the entire information furnished is correct, click the authenticate button. In case you find any discrepancy or any dispute about any of the details, please write suitable remarks accordingly in the space allotted in the format. In the event of a failure to undertake authentication verification, the authentication record should be marked as item. Well, I am not, whatever they Form D they upload now, that will be subject matter of a different challenge. But September 2025, they cannot be. Well, I am only to undo this earlier page 194.
So what is the prayer?
I am challenging this page 190, Lordship, page 36, P11. I am only challenging P11. I don't want to stop the authentication now, whatever consequence will follow. Page 36.
Immediately withdraw, cancel the resign and not to give any effect. This is your grievance.
So this P11 is that page 194.
Yes,
Let
who is
them do-
appearing?
So I appear for State Bank of India.
Hmm.
But we are the private respondent. No relief has been.
Who is appearing for NESL?
I do not think any NESL has been served because
no, we have served.
yesterday evening we received a copy of this
Yes,
petition
very
from the
much,
bank.
sir.
Now whether the NESL has been
My
served,
lord-
or Union of India is not represented,
Lordship,
neither they are a
how
party
can
to
he
the
say?
proceeding.
Just
This,
even not to go with them super fast. I am asking one
I
question.
am sorry.
You are
I
appearing
take
to whom?
I am taking.
You are appearing for whom?
I am from State Bank of India. Respond number.
You are appearing for
My lord, initial, my lord, the respondent number.
NESL.
Yes, my lord, my respondent
And
number.
see,
My lord, I have got the
he's appearing.
instruction, my lord.
He's telling that.
My lord, I have got instruction to appear before the lordship through
Okay, okay, no
telephone, my lord.
problem. Yes.
But I have not got received, my lord, the some relevant documents, my lord.
What
Even-
document?
Even the writ petition, my lord.
You have served NESL
Yes,
here.
it has been served. Most probably obviously served, my lord. But what instruction to appear and leave may be
Okay,
granted, my
okay,
time.
okay, okay. Give the copy, give the copy.
I'll give
Take,
the copy,
take
yes.
instruction. This simple
My-
matter.
my-
How if you have started the proceeding of 9th April 2026
Yes.
and it is continuing. Now, how you are telling that in the page 194 already authenticated on September
Yes, it is, my lord.
2025? That is the
I will submit appropriate submission, my lord. And then I will get an instruction, my lord.
take instruction.
Lord, I do not have any say, my lord. Only, my lord, one page, my lord, may I just show to your lordship, page 189. Their reply.
Hmm.
Lord, paragraph 3, lordship, you kindly take this. Lord, they knew about this default, and thereafter, paragraph 3, they have stated they filed a writ petition being such and such at the Calcutta High Court challenging such acts of the bank. Writ
Seven.
petition is pending adjudication before the Honorable High Court. In such circumstances, there can be no default attributable to the account of the company under the provision of the IBC or any act for the matter. Now, since the matter is sub judice, no further steps can be taken by any.
Correct.
The 7th May I have got.
Correct. That's why.
Filing of the writ petition, my lord.
No. It's only in this present date application,
Wait
the
a minute.
grievance of the petition, because the NESL is the they have initiated the Form C on 9th of April. You have submitted on 8th April demand information. So they have submitted on 9th April. Petitioner received and petitioner raised the objection, page 189. After the 189, it was disputed. Then page 192, they have rejected. Then again, if it is rejected on April 12th May, so how you have issued the Form D that it has been adjudicated, authentication completed on September 25?
But my instructions are we have already filed the proceeding before NC.
You may be, but with how when you have filed?
That minute I did not take the get the instruction.
So how it is pending that you take instruction? Also, you will take.
Madam, may I be permitted to submit before your lordship?
Yes.
With leave of your lordship, madam. If it is directed to file a affidavit in opposition,
That's
that will
correct.
be, my lord.
But in the
In
meantime,
details, my lord, it will be better. Subject to your lordship satisfaction.
that's you.
The prayer is.
Naturally,
Let them
if this is the small thing, how this if you bring the document now, this is already adjudicated, then April, why the April the proceeding has been
Yes,
initiated?
my lord. Not necessary.
Because as per your case, the bank has requested you on 8th of April, submitted the information on 8th of April. That information was forwarded by you, being the agency, to the petitioner by uploading on 9th of April. Petitioner has submitted his disputed in May, 9th May or 8th May, whatever it may. May. Then you have rejected on 12th May. If you are rejected on 12th May, so how the authentication completed on September 25? That is
Yes,
the
ma'am.
only question. And bank
That is
is
the
not
more
telling
question.
that you already
Defer, my lord.
initiated the
But then in the proceeding that they annexed it, last day's hearing, they come and show that this has been authenticated long back. That's what's triggered.
When you will come?
Next week, my lord.
Huh?
Next week.
Next week.
Or 2 weeks given. 2 weeks will be better, my lord. If it is possible, have
Where
your
is your
lordship.
office? And
Out of Calcutta, my lord.
Kolkata?
Yes, out of Calcutta. Out of Calcutta.
Out of Kolkata. The Learned Counsel appearing for the NESL submit that he has not received the copy of the writ application. Accordingly, petition is directed to serve the copy of the writ application along with the document to the learned advocate appearing for the NESL police. Learned Counsel for the responding NESL praised for time to take exception. Accordingly, cases adjourned. Let the matter appear on 9th July. On 9th July under the same heading within matters.
Lordship, 10 July if possible.
10th July.
And Lordship, no effect be given to this.
10th July, Guru.
And no effect be given to this because this is in the meantime on this
What
page
effect?
194.
He is telling that they already taken.
No, that is proceeding that they take, but let them not rely upon this page 194. That's all I am saying.
Actually, if it is so, if that is the interim order, well, actually, I have not got the instruction whether they are appropriate or not, my lord.
Taking
It will be very difficult.
set aside automatically,
My lord,
it
my
will go.
lord.
If the court
No,
is
but then if the
Other than-
company gets admitted to CIRP on the basis
No,
of this
upload is not
document,
text. Why is
that's-
it not text?
because that is
if it has, then come.
well, today's
If it- that's why you mentioned that.
today's NCLT hearing. Today's NCLT hearing. That's the whole. Let them proceed with the matter. I don't know, but let them not rely upon this document. That's all I'm saying.
Authority concern, obviously, my lord, it is pending before a lordship.
Page 194.
When it-
How you can rely that unless and until? But
Impossible to deny.
If you rely before the CIRP, then the petition will be
Authority
difficult.
concern will not take any step, whether it is pending before a lordship and already passed an order.
Till the next date of hearing, till the date of hearing, the impugned record of default in Form D, being annexure P11 at page 194 shall not be given effect to.
But instead of 9th, it can be on 10th of July. 10th. Great.
May it please your lordship. Now, this is my affidavit of service.
I have served the petition on them.
Who is appearing for the state?
I am for the Union of India.
Union of India.
Union of India.
What is the prayer?
My lord, the petitioner runs a partnership business, my lord.
Huh?
Petitioner runs a partnership business, my lord.
Okay.
Proprietorship business, my lord. It's a tea stall, my lord, at the
Ah.
premises of the respondents.
Ah.
My lord, a work order was issued on 17/1/2023, or work order 25, work order was issued, my lord. Subsequently, my lord, it was cancelled without giving me any show cause notice, as well as no opportunity of hearing was given, my lord. I was running a soothsayer business, my lord, because I was baffled to see whether they have not even called me up. They have given reasons which
What
are.
is the work order?
My lord, work order is at page. On page number 31.
'23. It's of 2023.
My lord.
For how many years?
My lord,
For how many years? The work order is?
My lord, my lord, it is renewable at the instance of 11 months, my lord. Subsequently, my lord, the
This is
cancellation.
of January 2023.
My lord, the cancellation order was on 18/5/2026.
Let you satisfy this code, sir. January 2023. So 11 months. So how it was extended? Where is the extension? Where is the extension?
My lord, there is no extension. It is also admitted on their parts. They have allowed me over there.
So then what has happened?
My lord, subsequently on 18/5/2026, my lord, kindly takes up page 39.
Page 39.
My lord, a cancellation order was given.
Page 39.
My lord.
Cancellation of allotment shop number.
My stall number was 17.
Correct. Treated as cancelled 30th June 2026. Requested to clear the dues. Yes.
My lord, an opportunity of hearing should have been given to me, my lord. No show cause notice, my lord. My lord, I was not allowed to say anything, my lord. Even the reasons that.
Yes, my lord. My lord, insofar as factual instructions are concerned, my lord, the instructions are yet to be received from the Vishwabharati University. But so far this license agreement is concerned, my lord, your lordship will find that there is an arbitration clause at page 34, clause 33. Any dispute arising out of this license agreement, save and except exclusions mentioned above, if not solved through negotiations, may, at the request of any of the two signatories to this agreement, be referred as a last resort to an arbitration committee, which shall consist of 5 members in total, 2 members nominated by the licensee, 2 members nominated by the licensor, and senior lawyer or retired judge jointly nominated by both the parties as fifth member. The decision of the arbitration committee shall be final and binding on both the parties. No suit or other proceeding shall lie.
No, any dispute arising out of this license agreement, save and accept the exclusion mentioned. Which
Yes,
exclusion?
there is. I do not find any exclusion.
My lord, it is framed by them only.
Which exclusion?
There is no
And
exclusion.
you have mentioned, and in the impugn notice 18 May shows that you have issued an order directing to vacate on the ground of the
Yes,
violation and
yes.
terms and conditions, not following all the things.
There, admittedly, there are violations.
So why you are not issued the notice? Directly you are directing to
But that
vacate.
is under the license agreement itself. The licensor
But
is.
whatever it may be, once you wanted to take back the premises, you have to issue the so-called notice. Or notice an opportunity why the agreement shall not be terminated. Directly stated that you vacate the premises.
But that is within the scope of the license agreement itself.
Where is that?
Kindly.
By giving yes. Where is that? By giving licensee 3 months notice in writing. Kindly come to the 29.
My lord.
Kindly come to the 29.
The licensor shall have the right to terminate this license anytime before its expiry within 3 months notice in writing and in advance if it requires to allot the premises for its own use, and with 1 month's notice in writing if the licensee violates any of the terms and conditions.
Correct.
1 month's notice is there.
And not or and.
Yes. Writing
First
violation.
you have to give the 3 months notice, then and violation.
My lord.
The licensee shall have the right to terminate this agreement any time during the aforesaid term by giving the licensee 3 months notice in writing. So, my lord, insofar as this agreement is concerned, my lord, under the agreement, my lord, they were to start the stall within a certain period, as mentioned. But they have done so in the month of November 2025. 2 years after that, my lord. That too without making any payment. They themselves, my lord, they themselves asked for payment. For depositing a payment on 10th of November 2025.
That is not the ground, sir.
But they are all mentioned.
They come to the page 39. The first allegation is that he has occupied the excess space by placing chairs.
Various allegations.
The second thing is that he not followed the color and texture.
Yes.
So he has not properly colored the premises where the stall has been erected. Then third is unauthorizedly using the university premises by erecting pandals. And said, then due to the mismanagement, the customers visiting you sometimes indulge in the creating disturbance. These are the 4. Then you have violated the clause number 1, 2, 3, 4. What is the 1?
3, 5.
Entire clauses are mixed question of law and facts, my lord. I need to be there to make my submissions over there, my lord, before the hearing authority.
You do one thing. And one
is the company shall erect and run operate at your own cost.
Correct.
Install temporarily.
Okay, so erection is in access area. 2, license shall build the erect and food stall. So yes,
by means of prefabricated.
Okay, I am saying it. You want to file or otherwise I will dispose of. Setting aside this, if you wanted to evict the petitioner, you take appropriate steps in accordance with law.
But they are supposed. My humble submission.
Stay this order. 3 months you are not. You have issued the notice on May and asking you to vacate on June. Where is the 3 months?
But there is a forum agreed upon by the parties.
That I will decide.
Lordship.
That I will decide. I am keeping the mentality open. If you want.
Yes,
if you want to file affidavit, then I will see
my
that.
preliminary objection is there, my lord, on the maintainability in view of the arbitration clause, my lord. My lord, kindly take that note of that.
The petitioner has filed the present writ application challenging the impugn notice dated 18th of May 2026, wherein the registrar Vishwabharti has directed the petitioner wherein the stall number 17 at Bharat Tirtha Complex, Vishwabharti, allotted to the petitioner on 17th of January 2023, is treated as cancelled with effect from 30th June 2026 and directed the petitioner to vacate the same after payment and to clear the dues of license fee from the month of December 2025 to May 2026 at the rate of 5,400 per month and to vacate the premises. Now, counsel for the petitioner submit that before issuance of the said notice, no opportunity of hearing was given, no so-called notice has been issued. He further submit that as per the terms and conditions of the allotment order dated 17th of January 2023, 3 months notice is required to be issued and to be given for vacating the premises, but instead of following the provisions as following the terms and conditions of the allotment order, the respondents have issued the notice by cancelling the allotment of the install of the petition. Now, counsel for the respondent submit the writ petition is not maintainable as in the allotment order there is a clause of arbitration, and if any dispute arose between the parties has to approach before the arbitration committee, but instead of approaching the arbitration committee, the petitioner has filed the present writ application. Now, counsel for the respondent prays for time to file affidavit in opposition by keeping the mentality of the present writ application open. Had the land counsel for the respective parties peruse the materials on record, this court find that the respondent authority have issued the notice to the petitioner on 18th of May 2026 by treating the allotment order cancelled and directed the petitioner to vacate the premises by 30th June 2026. And as such, if interim order is not passed, the petitioner will suffer irreparable loss and injury. According to the interim order dated 18th of May 2026, operation of the interim order dated 18th of May 2026 is stayed for a period of 6 weeks from date till 11th of August 2026 or until further order, whichever is earlier. The respondent directed to file affidavit in opposition within 3 weeks. Reply, if any, there to be filed within a week thereafter. List the matter on 10th of August 2026. The mental application is kept open.
My lord, today is the date of eviction, my lord. Kindly direct them to communicate this order.
The petition is given as the today is the.
Well, there is no mention in the application of that any eviction.
What?
There is.
Lordship,
what?
38.6. But Lordship will kindly just. I'm praying for this indulgence, my lord. Page 40. Lordship wants page
40.
Page 40.
40.
Yes. The university will develop and beautify the area surrounding Shantiniketan Post Office and Bharat Tirtha Market for its own use.
Correct. You find the affidavit. That's why you have to establish it is correct. It is correct.
And this term 29 also provides.
Given liberty to communicate the gist of this order to the authority at the date of eviction is and the authorities are directed to act on the gist of the order, if any, communicated by the petitioner. Yes, next.
I'm grateful, man.
Grateful, Lordship.
Item number 10, I'm for the petitioner, Your Lordship. This is my writ petition challenging a unilateral freezing of my bank account and placing a lien on the account.
Yes.
I'm covered by Your Lordship's order. Judgment dated.
Which for the bank?
We have.
None appears on the petitioner. Which for the bank? Where is the affidavit?
Yes, Your Lordship.
Which bank?
I'm filing Standard Chartered Bank, Your Lordship. And on the last occasion, they arrived. Yeah. On the last occasion, they had appeared also, Your Lordship.
Only once February it was listed. Nobody, the combined monthly is April. No, it has come today.
It was not perhaps.
Where is the service?
None appears for the. Sure. Very well. May I just show I'm completely covered
No,
by.
but the bank is not there.
We'll serve notice again, Your Lordship, and come back.
Affidavit service filed by the petitioner be kept in the record. In spite of service of notice, none appears on behalf of the respondents. For the petition is directed to inform the next date of hearing to the respondents and to file the affidavit of service, fresh affidavit of service on the next date fixed. It is made clear that on the date fixed, in spite of service of notice, if none appears on behalf of the respondents, comma, the matter will be taken up for hearing in the absence of the respondent. Please the matter on 9th July
Very well.
under the same heading. Next.
I'm deeply obliged.
Under 11, your lordship need not open the brief, my lord. The other batch of matters, my lord, is appearing tomorrow, my lord. Your lordship's desire was, my lord, I should remind your lordship when the matter is called on today, so that, my lord, all matters may be taken up tomorrow, my lord.
Tomorrow at 2 p.m. 12 noon. 12 noon.
12 noon. 12 noon, my lord. That's your lordship's order.
Those matters are matured for hearing.
This is not matured.
This is new matters.
No, no, my lord. These
If they want to do it together, I am
right. So they will come back tomorrow. my lord.
It's after all their matter.
There is some development in the matter. Development in the sense that central government already passed an order, my lord, in the month of April 2026 for SFIO investigation. Under section 2121C.
Well, we'll come back tomorrow, my lord. I'll have all together, my lord.
And then at counsel for the petition submit that the analogous matter is fixed tomorrow at 12 noon and paid for fixing the same on tomorrow at 12 noon.
Obliged.
The submission made by the counsel and let the matter appear tomorrow along with the connected writ application at 12 noon.
Obliged, my lord.
Next.
On the 12th, my lord, I am for the petitioner. My lord, it has come up at my instance affidavit of service. But it has been served in the month of June, my lord, on the new
Month of June.
Yes, my lord. It has been
2025.
No, 26.
Which department?
My lord, Department of Health. My lord, matter relates to kidney transplantation. Your lordship has already passed an order. My lord, similar issue. My lord, I have been once called by the committee. They were not satisfied. Again, they called me.
Who is the donor?
My lord, donor is a friend, my lord. Out of love and affection, I have stated that on affidavit.
Whether police verification was done.
We have nothing been just like the
financial implication has been seen.
No, my lord. There is no. We have stated there is no financial implication. My lord,
What is the financial condition of the donor?
My lord, I have given the my lord income certificate of both.
But the police verification is
My lord, that has not yet been communicated like the previous matter. Your lordship directed the state to come up with that report.
Yes, you are appearing.
No, my lord. Mr. Sudipa Banerjee is appearing.
Huh?
Mr. Sudipa Banerjee is appearing. Is standing in leg in court number 50. Kindly short possible.
Okay, Pastor, let's see come. If not, then I will direct the police, let the file the report with the police verification and the financial.
My lord, may I make one humble submission, my lord? If your lordship pass the report, pass a direction to file a report, I will communicate that
No,
to.
let they come. Otherwise, they will say I was not there.
Your lordship is passing it over.
Pass over. Next.
Ten six. Kindly see, my lord, the last order passed by your lordship, my lord, on.
Please give.
অলরেডি পিপি চেঞ্জ করেছে। রিপোর্ট দিনের মধ্যে আসবে, আমরা একটু চাপে ছিলাম।
Yes.
Practical difficulties, which are, I don't know what is the report submitted by the learned student. But the practical difficulties we are facing. If your lordship collect your lordship's order, that is on 5th of May 2026. Correct paragraph 6.
Yes.
The paragraph 6, your lordship kindly turn the next page at the bottom, just above the paragraph 7. Your lordship has recorded. You can just press it. He further stated that after consultation with the learned public prosecutor Mohammad Abdul Rauf, Barasat Court, photocopies of the available portions of the case diary have been collected, and available photocopies of the case diary containing the page number 1 to 39, which includes as follows: FIR, written complaints, Surathal report, ministerial inquest report, one serial list, rough sketch map, statement of some witnesses recorded under section 161, postmortem report of the deceased Sonali Dotto, and copy of the charge sheet. Now, these CD, duplicate CD containing 39 pages. What was handed over to the London public prosecutor, newly appointed public prosecutor, 3-4 pages only. 3-4 pages only. This CD, my lord, your lordship, my lord, kindly direct the concerned officer to produce this CD, my lord, duplicate CD containing, my lord, 1 to 39 pages. My lord, what they are doing, my lord, this is absolutely, my lord, they are doing massacre. The person who against whom I made an allegation, this Abdul Rauf, public prosecutor, he has done all these mischiefs. And now they are collecting the document from him. They are collecting the document from the accused persons. And after collecting the documents, they are handing over 2-3 documents to me as well as to the public prosecutor, newly appointed public prosecutor. Now, your lordship directed the concerned court to expedite the trial. The concerned court is expediting the trial without supplying the copy to the public prosecutor and as well as to me also. The peculiar situation has been created by this, by doing all these things. And the response number 8, who is a concerned person, was holding the post of public prosecutor in this case. He has done all these mischiefs. Despite that, the court is also collecting the documents from him. And this CD, which was, they have referred 39 pages. Now, what is that CD? I am asking the question to myself. Let them produce the CD so that I can collect it from this court. Well, original case diary, there must be an inquiry. Your lordship, I have prayed for that. The original case diary, duplicate case diary, all gone. And this is a case of 2009.
No, the report has been submitted. Report is submitted. There was a GRO.
Yes.
There was SI rank GRO was there. His responsibility, but when CRM was filed before the High Court.
Yes.
At the time of hearing of that CRM, the GRO has handed over the case diary to one Rajyasri Das.
Rajyasri Das.
And from there, the report has not been, the CD has not been written.
Kindly, may I just, don't take me otherwise. 2009 case.
Correct.
2009, a police constable is involved in this case. Now, 2011, there was a change of regime. And after the change of regime, everything has been given absolute go by. Duplicate case diary is not also not available. And the CD, they are preparing the case diary, 1 to 39 pages. Let them produce that first. Let us see what is there. We are not getting.
CD, there will be one CD in the police station. There will be in the SP office, TP office, and one is in the court.
Yes.
In the court.
Yes.
So all three
gone. But this is this. There cannot be more than any mystery like this. Strong action is required. I visit your lordship, learned additional Advocate General is also here, kindly appoint him in this case, so that he can exercise his office, good office. But this is that's the key of just like case. CD meeting chalo. If your lordship, so if I can get a copy of the report which has been submitted, if you are also sorry, let me also go through it, or may be permitted to go through that.
So why the document is not available in the case criminal court record?
Everything has been taken. I don't want to
It's
say
very serious in nature. As far as the criminal case is knowledge, if the police has investigated and submitted the charge sheet, there should be 3 sets. One should be in the police station itself. One should be in the in the court, and second is with the GP or PP. If it is given to the PP, if it is not given to the PP, it will be remain with the GRO. Okay, the original is with the GRO that has been misplaced. What about the document which was lying with the police station? This
But,
second copy of the CD.
Let me find out, my lord, and come back before your lordship, my lord.
The police is also not, then I have to call the SP here.
I'll have a word with the SP and I'll come back, my lord, for your lordship.
No, one request I'll make, my lord, for the timing, my lord, let there be a stay of interview.
For what?
Stay of, my lord, for the.
Why?
Let there be a stay.
What is the stage of the trial?
Which evidence is going on?
How the evidence? How the witness will?
This is my case.
How the witness will depose without the 161?
This is my case, my lord.
And how the defense will take the contradictory of the 161 or the prosecution examine the witness without the 161 statement?
Kindly see, my lord, the way, my lord, the judge is proceeding. Judge has fixed the date, my lord, in the month of August. As because your lordship has directed to expedite the trial. Now, my lord, CD is not available. Now, my lord, 161 statement is not available. Now, case is fixed for trial, for recording evidence in the month of, my lord, August. So, my lord, let there be a further timing, my lord, let there be a stay. Or in the meantime,
Let me come back on Friday, my lord. I'll
Come on
have a
Friday.
word with the concerned superintendent of police and come back.
Let it appear as to be mentioned, my lord. Otherwise,
The report submitted by the district judge in compliance of the order passed by this court dated 5th May 2026 and the 10th June 2026. We kept in the record. Full stop. Learned AAG prays for time to take instruction in the matter. Accordingly, cases are adjourned. Let the matter appear on when?
Keep it on Friday, my lord.
On 3rd July, under the heading to be under the heading for orders at the top. Further orders at the top. এটা কাজ করুন
ওসিটা
আইলে না
আচ্ছা প্লিজ
চেম্বারে
একটু আমি বুঝিয়ে দাও কি জিনিস ফাইলটা
ना सर्वर पे सब पे आपको टाइप करके भेजेगा ना
Dada.
ओ पासवर्ड
Item number 12, my lord.
yes
My lord, kindly fix a date for file a report, my lord.
no report you have to file report with regard to whether the donors
Yes, my lord.
correct
On
donor
last
yes,
yes,
police
yes.
verification is conducted or not with regard to the donor and
Yes,
what
ma'am.
is the financial capacity of the donor.
Yes, my lord.
Learned Counsel for the state press for time to file report with regard to credibility of the donor as well as the financial condition of the donor. Let the report be filed by
My lord, next week, my lord. 15th.
8th of July 2026. Release the matter on 8th July under the same heading.
Much.
My lord, service may be kept. Affidavit is kept in the record. Next.
Clearly clear matter.
14?
15 and 18.
14, 15, 18.
I think item number 14, my lord.
You are appearing.
15 and other.
Your lordship,
Well, I am appearing on 15, man.
on the companies that the notices were issued under 2.7 without there being formation of any opinion. So these restrictions are of similar nature. I credit your lordship that the union has preferred an appeal. All I am today, but there is no stay. That appeal will be taken up. All I am today seeking, let them file an opposition. Later, a similar stay was granted to those notices in that writ petition also till it was finally dismissed. So today I am only praying let a stay of that notice be granted and let them file their opposition and your lordship may keep it.
In the division bench, my order is stayed or not?
No.
No stay is there.
My lord, may I submit? I am appearing in 15, my lord. My lord, the application is premature as the show cause notice has been issued. There are several judgments, my lord. The show cause notice should not be entertained in a writ petition unless or in the rarest of rare case, my lord. My lord, may I cite one judgment, my lord? Application is not maintainable at all, my lord.
That point can
And I kindly see the notice. I have already asked the certain documents to place, my lord. My lord, may I submit, my lord? May just. My lord, officer is exercising his statutory power given under the act, my lord. I have asked them under 217 to furnish certain information with regard to the certified copy of the documents in the matter of their companies. Investigation into the affairs of the
when the proceeding was initiated.
First it was under
2023. 28th of August 2023, my lord. They have come up with the writ application in writ application is, my lord, 2026, my lord, this year, my lord. No steps has been taken as yet, my lord. My lord, I have certain points, my lord, in this matter, my lord. The application is premature. They cannot avail the writ application like this, my lord, because, my lord.
So you don't want to file the affidavit, you want to argue the matter on maintainability.
Well, I can fight, but I can.
No, you take one stand. If
I
you
want to file, my lord,
you
but
want to file the written
yes, my lord.
affidavit in opposition, you file the affidavit. No, I am keeping the maintainability open. If
My
you
lord,
think
yes,
no, you will not file the affidavit in opposition only on the point of maintainability you want to argue, then I have to.
No,
I have to
I
hear
shall
the
file
matter.
my opposition, my lord, but
A similar interim order was passed in the earlier date, your lordship, which was continued for
But
about 2 years.
they are raising the point of
my lord,
how
the
can
entry,
it
my lord, the points.
It was raised and it was kept open, but the stay was granted.
My lord, I am opposing the stay, my lord, also. I am opposing the stay also, my lord, because I have a right to exercise my statutory powers given under the Act, my lord. And whether the lordship has to see, my lord, whether the petitioner has acted honestly and diligently or not, or whether they should be excused from the criminal liability at this stage.
No. There is no.
And my lord,
I am not challenging. I think perhaps my learned friend has gone wrong. First, there was an investigation at 2065. Thereafter, this 217 notices have been issued. In the meantime, in the 208 report, there was no opinion or finding against me for initiation of the 217 notice.
Opinion is there.
No. There's no opinion.
And then, my lord, question of delay, my lord.
Where is the notice?
The lordship, the notice is at
Page 81, my lord.
page in page item number 15. The notice starts at page 88.
Item number 14.
14.
Yes. Page
88 onwards.
217.
217.
Correct. These are 2023. Then what has happened?
There were multiple companies, your lordship. Then 2 writ petitions are filed. In those, it got succeeded. Thereafter, these writ petitions were filed based on those judgments, your lordship.
No, after the 2023 notice,
Lordship.
actually, what has happened after?
Actually,
After this notice, what has happened?
your lordship, we have given them. We have been cooperating with them. We have given them whatever has been required. It was earlier was given under 2065, and we have again given all those documents, whatever was required. But today we have come up before your lordship that this second round of initiation of investigation under 217 could not have been done without there being a formation of any opinion. Under the Act.
So that's why I'm asking when the first proceeding was initiated.
First, the proceeding was initiated. If your lordship takes the annexed P1, that is at page 51. That was initiated January 2019. So in January 2019, when we received the 2065 notices,
correct,
we have cooperated, given them all the documents, and then the 208 report, which is at 77. They conducted the inspection for 11 months, and finally, the finding was there. In the conclusion, if your lordship takes page 83, nothing irregularity was found, except minor violations for which they have initiated NCLT proceeding and criminal proceeding, which we are contesting there. I am not challenging that those proceedings be set aside. But I am the second action of 217, further investigation, without there being any opinion. Today we have come up before your lordship with regard to that. That was the identical case in that Ayushman tie-up judgment, which your lordship was pleased to hold, that since there is no prima facie holding, that judgment is also part of this writ petition at page 146. At 146, 158 is the operative portion. This was your finding that without the opinion, there has to be a substance.
Contest করতে কিন্তু সবচেয়ে তো ফাইল হয়।
Yes.
So that's why I'm saying today let them file their opposition.
Conclusion part. Page 70. Page 78.
Conclusion part.
Learned counsel for the respondents praised for time to file. Learned counsel for the respondent raised the point of maintainability and also praised for time to file affidavit in opposition. Let affidavit in opposition if filed within 3 weeks. 3 weeks. Reply if any there to be
4 weeks.
4 weeks. Reply if any there to be filed within a week. Within 2 weeks thereafter. The maintenance the writ application is kept open. Please the matter on 25th of August 2026.
Lordship,
Grateful
what your
one.
notices be stayed in the meantime, Your Lordship?
No. Next.
Lordship, that will prejudice because Your Lordship.
No. Next.
There's no file.
You persons are watching one case you filed and 2019 you are proceeding. In one case order has passed. Now you are starting filing the series of case and the similar or let the case be taken off hearing. Yes, next.
But at least Your Lordship,
Correct.
They are on the same footing, Your Lordship.
2019 till date nothing has
But not 2019.
identical. Yes, who is for the petitioner? Might I appear for the petition?
Few of the private respondents.
And I appear for Union Corporation.
What is the matter?
But this is a matter relating to tender for my lord road transportation of bulk petroleum products tender floated by IOCL. And there has been gross irregularities in the tender process. We are not challenging any condition of the tender. We are challenging the decision making process. Now, kindly take the tender first. My tender, your lordship will find starts at page 22. Volume 1.
Transportation of bulk products.
This is road transportation of bulk petroleum products, black oil, location, Haldia refinery terminal. I will kindly take, my lord, the scope of work, which is at page 24. The location has been indicated, defined, and my lord, the tank truck requirement is 16 metric tons and above, gross weight to be governed by RC book 80 numbers. Now, my lord, now kindly take, my lord, the pre-qualification criteria, which is at page 25. My lord has got that?
Yes.
Kindly take serial number 2. Maximum number of TTs to be offered by the bidder. Numbers, 5 number of TTs. Well, this is
Page
5 number.
25.
Page 25. Well, the table. The table that is the heading is pre-qualification criteria.
Correct.
I am taking a lordship through serial number 2. So minimum number of TTs to be offered by the bidder. 5 number of TTs to be offered, out of which minimum 3 should be owned. 2 number of TTs to be offered, out of which minimum should be 1 owned, and bidders can participate with ready bill TT or purchase a sale invoice with the booking slip for chassis. Now, the another requirement is that RTO registration, certified copy of registration certificate.
No, what is the meaning? The minimum number of TTs, 5 numbers TTs to be offered.
Minimum, that is the minimum offered that one has to.
Minimum of the 5 number TTs to be offered, out of which 3 should be owned.
Yes.
No problem.
Right.
Now the second.
That is for SC/ST category. The next column is for the SC/ST category, but our case is not SC/ST category.
That's why I'm telling you.
Right.
Okay.
Well, absolutely, man. I'm so sorry, man. Now, we'll kindly take the RTO registration, which is the requirement. They have to submit self-certified copy of the RC form 2323A to be submitted for each offered tank truck.
Yes.
Then calibration certificate is to be submitted. Now, some other conditions of the bid document. Kindly take, my lord, serial number 3 under the head Instruction to bidders. Page 26. But these are the maximum number of TTs that can be offered by a bidder is 88 TTs.
8
TTs.
Maximum number of TTs can be offered by the bidder
8
is
tank
8.
trucks. 8 tank trucks. Now, my lord, kindly take now, my lord, page 30. But what is the procedure to be followed when more than one party has quoted the same rate? That your lordship will find at page 30 under serial number 3.
So one bidder cannot go beyond the 8.
Right, and they cannot go. 8 trucks is the maximum.
Correct.
Now, my lord, now kindly take clause 13, which your lordship will find at page 54. Yes, I'm sorry, my lord. One more thing, I must point it out. Kindly come back to my lord, if your lordship so pleases. Page 30. And it should be maximum number qualified it is offered. Yes. Now I take your lordship directly.
Where from you are reading? Page 30.
Page 30, my lord, under the same head. My lord, under
Maximum
the
number
allocation in the above sequence will continue till locations quota of SC/ST is fulfilled. In case more than one party has quoted same rate, seniority shall be decided in the following criteria. Some number of qualified owned TTs. So he has to own. My lord, the ownership requirement your lordship has already seen at pre-qualification criteria. Now, my lord, kindly take serial number 13.
Serial number 13.
13.
Page.
And that is at page 54.
Yes.
The documents for the tank trucks mentioned shall be liable for verification. If forged documents are submitted or any information is found to be incorrect, the tender shall be rejected. And if the contract is awarded and detected subsequent to award of contract, the contract shall be liable to be terminated and IOC shall be entitled to recover such damages, losses, claims, etc. as the IOCL may undergo. The security deposit will be forfeited. Now, clause number 14, my lord. IOCL can appoint third party for verification of documents, inspection of tank trucks, for construction of tank, safety fittings, etc. IOC's safety aspects requirements and other specific requirements such as security locking system, vehicle tracking system, button loading arrangements, color scheme of tank trucks, etc. So, my lord, the conditions specifically provide that the tender would stand rejected if there has been a misdeclaration. So, my lord, I will not, my lord, beat about the bush. I may take your lordship directly case by case. But my lord, we have from paragraph 6 to paragraph 19. But we have given a list of the participants and we have also indicated what are the deficiencies or the incorrect particulars furnished by the participants. So, may I take your lordship to one such case? One. Kindly come to my lord, Amar Transport. Your lordship will find its reference made at paragraph 6 of the petition and the corresponding document at pages 200 to 210. My lord, I take your lordship directly to Amar Transport first.
Paragraph 6.
Paragraph 6. Kindly take paragraph 6 of the writ petition. Well, we have found that in most of the cases,
you have done injustice to this court.
I'm sorry, my lord.
Not provided the page 8, page 10.
I'm sorry, my lord. Page pagination not done. I'm sorry.
Writ petition page number is not there. I can understand the annexer cannot, but here the writ petition page is not there.
Extremely sorry, my lord. My lord.
The petition is as abstruse as the allegations are.
Yes, my lord. Sometimes, my lord, behind, my lord, everything.
Now the what the writ rule can be issued? Discrepancies in the writ petition.
May I just have a?
May I just suggest this to cut it short, my lord? I understand the grievances of.
Yeah,
my-
there the-
No, I am not a, or not only.
Let them, my lord, repaginate.
Check the page. No, not repaginate. The page is missing.
I'm just.
Stitch the pages, my lord. Once upon a time. In the meantime, my lord, I find that their grievances, my lord, that there might be some false documents and there may not be proper verification done. Let them, my lord.
Paragraph 6 is at page 8. I'm sorry, my lord. My lord, may I just place my case?
Where it is?
Page 8, paragraph 6, my lord. I'm sorry, my lord. Your lordship has got the pagination, my lord. I'm sorry. At the top.
Yes.
I'm so sorry, my lord. I should have indicated, my lord. It's my failure. Kindly, my lord, now take your lordship will find, so far as our transport is concerned, my lord, we private.
What is the suggestion, Mr. Bhattacharya?
The allegation of the petitioner is that there was no proper verification, there might be false documents which were introduced. So far as my clients are concerned, I am ready with the entire set of documents and we have no objection, we do not stand in the way if clause 13 and 14 of the tender conditions are invoked, and the report is submitted to you. We have it.
My lord, I do not know, my lord, I believe Mr. Bhattacharya is appearing for respond number.
I am appearing on behalf of some of the successful
Yes.
tenders. Respond numbers 8, 10, 14 to 17.
10 is extremely important. My lord, kindly take 10. My lord, one submission, my lord, one submission. My lord, the fairness in the stand taken by Mr. Bhattacharya indicates, my lord, that the client might not have been so fair. So, my lord, kindly take, my lord, the petition. Kindly take page 200. My lord, what has happened in this case? This is a typical case of armed transport. Kindly take, my lord, this is the invoice.
Which page? 200.
My lord, they are two, my lord, they can place the
Page 201.
201, I'm sorry. 201. Second volume 201. My lord has got that?
Yes.
But this is 201. Now, your lordship will find this is the invoice. My lord, they are to place trucks. My lord, the tender conditions say that they can place trucks. The age of the trucks should not exceed 14 years. Now, these bidders who have turned out successful, they have placed trucks which they have newly purchased. That they have also disclosed or enclosed the registration certificates. Now, kindly take this case. My lord, kindly take the tax invoice. This is 11th of April 2026. Has got that?
11th April, yes.
Yes, your lordship has got that?
Yes.
Now, my lord, kindly now take the registration certificate,
202.
which is at 202, page paragraph. My lord, kindly take, my lord,
Card generated.
smart card generated. My lord, there are,
April 2020.
your lordship will find at the bottom, just, my lord, before the completed approved, your lordship has got that portion. Completed approved on 8th April 2026. My lord has got that?
Completed approved.
But there is one column before the middle. My lord, this is just before the dispatch RC generated.
Yes.
I am on completed approved.
Yes, completed approved.
My lord, 8th April. So, my lord, the generation, the submission, the application for registration has been made prior to purchase of the truck. And, my lord, the RC has been generated prior to purchase of the truck. And this has happened in most of the cases. And the bid has been submitted on 9th of April. The RC has been generated.
Along with the set of documents, we are ready with it.
My lord, I will come to that. I will come to that. My lord, this is one. Kindly take, my lord, the retail tax invoice first.
No. Okay.
Yes.
So this is page 201. What is the engine number and chassis number?
Yes, that is what I'm on. I should have. Kindly take the chassis number. My lord, the last 4 digits are 4481. Now, my lord, kindly take, my lord, the chassis number in the RC. কত কোন পেজে আছে বলো? হ্যাঁ 210 আছে, কারেক্ট। না স্যার, ওইখানে এটা কোথায় আছে ওটা দেখাতে হবে না। Kindly give me 1 second, my lord.
provided the RC also, it's the same.
I will. Let Mr. Manage.
মানে the RC টা কোথায় আছে? RC টা কোথায়?
210.
210.
You have given the chart.
I have given the chart. না এইখানে কোথায় আছে? এখানে কোথায় দেখা যাচ্ছে স্যাশি নাম্বারটা? হ্যাঁ। Oh, my lord, the vehicle number is there in the RC. So it can be compared with the vehicle number.
Correct. Vehicle number. What
Vehicle number is there. Your lordship will find.
202. Where is the vehicle number?
My lord, your lordship will. My lord, 210.
No, 202.
Yes.
Where is the vehicle number?
Well, your lordship will not get the vehicle number in the invoice. Oh, top
202.
202. Lordship is talking about 202.
202
is the invoice. But at the time when a
202 is the
invoice.
smart card.
No, 202 is the invoice. I'm sorry.
201 is the invoice.
202
is the smart card.
202 is the
Website-
smart card.
Website code.
207.
দেখুন ভেহিকেল নাম্বারটা মিলিয়ে দিন।
My lord, kindly compare 207 with my lord 201.
210
210.
210 bottom
207, your lordship will find the vehicle number.
vehicle number at the top.
At the top, my lord, this is BR01G.
Which one? Which one?
My lord, 207. At the top,
BR01 GR0612.
12. Now, my lord, kindly compare along with, kindly take my lord now page 210. Now, my lord, lordship will find from 210 the vehicle number at the corresponding SASHI number for vehicle number, registration number BR01 GR0612 is 44481, the last 5 digits.
Yes.
Now, my lord, kindly take the page 201. Your lordship will find the SASHI number is indicated in the tax invoice.
4481.
Yes.
Yes. So, my lord, today, my lord, we have got a peculiar case. My lord, at the time of making an application for registration, in accordance with section.
With regard to 201,
right,
which you are relying upon the invoices of
right,
1st April 2026,
right,
and you are relying upon the smart card of 202.
No, 207.
207.
207.
207.
Correct. 207 you are relying upon.
Right.
Relying upon, and this generation was made on 7th of April.
April. My lord, the smart card was generated on 9th of April.
The smart card was
Generated on 9th of April. At the bottom, your lordship will find that.
Smart card generated 9th April.
9th April. Your lordship has got that. And the entire process was completed or approved. My lord, the generation of smart card process was completed or approved on 8th April 2026.
Correct. 8th April, not 9th April.
No, 9th April, my lord, it was generated. It was dispatched.
Okay.
It was
11th.
Yes.
dispatched on 11th.
Yeah, generated.
And then dispatched on 11th.
Correct.
While the bid has been submitted
At page 200.
page 200, the lordship kindly takes the bid has been submitted.
So this is with regard to the BRO
BR01
01
0612.
12. And what is the chassis number?
SASHI number your lordship will get 4481, which your lordship will get in my invoice. SASHI number is there under the head description of invoice. The engine number is also given, SASHI number is also given.
The 6.
Yes.
Serial number 6.
No, yes, my lord, the lordship is at page 20.
Yes. 210.
210 serial number 6. It's just 1 minute. Yes, serial number 6.
Yes.
So 8 vehicles, we have given details of 8 vehicles. In all these cases, the invoices were, well, the tax invoices were issued on 11th of April. My lord, the RC was generated on or about 8th or 9th April. RC was dispatched on 11th of April and bid submitted on 9th of April.
বলছে যে আমাকে RC দিতে হবে bid।
Bid submitted on 9th of April.
Yes.
Lordship has got that?
Yes.
So, my lord, kindly now take, along with this, we have given the details of most of the bidders. Kindly take the next one. My lord, the lordship will find on maximum 8 vehicles can be placed as per the tender. So, Amal Transport, whose proprietor is Amal Kumar Sheet, we have got the details of 8 vehicles. For Suraj Road Lines, we have got the details of 7 vehicles. We have given the invoice date. In this case, the invoices were generated on 30th April 2026. And my lord, today, if your lordship kindly takes rule 47 of the CMVR for once, the waiter, kindly take rule 47 of the CMVR. My lord, for rule 47, your lordship knows better than all of us, has to be read in conjunction with section 41 of the Act.
Rule, which rule you are referring?
Rule 47 of the CMVR. Flag, my lord, we have flagged it. Your lordship will find, kindly turn over and take the next page. Your lordship will find the registration application has to be submitted in form 20. And along with the registration application, what is required to be submitted is the invoice, the certificate of insurance.
Yes.
Certificate of insurance. So, my lord, this is the law governing, my lord, registration of vehicles.
Yes.
So, my lord, by no stretch of imagination, my lord, I am now putting the question to myself with all humility. It could be said that these vehicles could have got registered prior to the generation of the tax invoice, because tax invoice is a primary document for obtaining registration. We have given details, my lord. Take one by one. Suraj Road Lines details we have given at page 211. Then Durgapur Oil Carrier, we have given the details at page 224. Then, my lord, Unit Traders and Movers. 224, my lord.
Yes.
224. Unit Traders and Movers, we have given the details at 236. Then, my lord, Shivam Bulk Carrier, we have given the details at page 258.
Yes.
But so far these bidders are concerned, this is the, my lord, the patent anomaly.
Yes.
There are other bidders where we find that the certificate of, before, my lord, obtaining the certificate of insurance, my lord, the bid was submitted. When the registration and the RC was also generated. When RC could not have been generated before issuance of certificate of insurance, again, certificate of insurance is another primary document which is required to be submitted along with the application for registration of vehicles. My lord, this issue, my lord, we took it to the Honorable MP, who is also member of the, my lord, this consultative committee, Ministry of Petroleum and Natural Gas. This is very interesting. My lord, the MP writes to the IOCL that kindly examine this issue. There are 2 writings. With respect to the first writing, which is dated 22nd of April 2026, so it was as early as on 22nd April 2026, we registered our demand. 22nd April 2026, my lord, the MP writes to IOCL. In response to the writing dated 22nd April 2026, what does IOCL say? Your lordship will find at page 324. But the type copy is at 324. There is the original Hindi version is at page 321. Kindly, my lord, mark the date for your lordship's kind consideration. The date is 20th of May 2026. Your lordship has got 20th May 2026. Now, my lord, kindly now take page 328. We assure you, well, this everything has been pointed out. We assure you that the entire tender process. Kindly take paragraph 3 at page 327. I'm sorry, my lord. It is clearly mentioned in the tender document that the. I'm sorry, I'm so sorry, my lord. I'm so sorry. I should have waited.
Yes, no problem. Continue.
I'm sorry. My lord, it is clearly mentioned in the tender document 327. If your lordship can take.
Yes.
It is clearly mentioned in the tender document that the registration of the RTO shall be verified before the issuance of the letter of acceptance. If at any stage any documents are found to be forged, or if information has been given to be found to be false, then the concerned bid shall be rejected and proper action shall be taken as required. Kindly take paragraph 5. We assure you that the entire tender process shall be held with complete transparency and in compliance with the prescribed guidelines of proceedings, if at any stage any discrepancy is found, then necessary action shall be taken in accordance with the tender provisions and the rules that are applicable. Lordship has taken the date, that is, my lord, 20th May. Kindly take the date of the tender summary report, which your lordship will find at page 193. Volume, it's volume 1 or volume 2? Second volume. While the company writes to MP that the process is going to be undertaken in a fair and transparent manner, the bid summary report is already prepared on 20th of May. On the very same day.
Yes.
So, my lord, this entire writing, this entire, my lord, kind of.
What was the last date for submitting the bid tender documents?
13th April.
30?
April. 13. 13th April was the last date. My lord, we have already indicated, my lord, how, my lord, the vehicles have been purchased and how RCs have been obtained in this case. Admittedly, there has been no verification by IOC in spite of the assurance given by the IOC to the, my lord, the
When the tender was open?
Tender was opened on the financial, my lord, the technical summary was given on 20th May and the financial bid was opened on, bolo? Date ta bolo.
Page 191. Publish it.
16th?
No, publish it.
No.
Bid opening date 14th.
Because the last date was the 30th April.
30th
When the
April.
technical bid was open.
Submission end date was 30th April.
No, bid opening date. Bid opening date was 14th April. 14th April. 14th April. 14th April. 14th April.
14th April 2020.
So immediately we wrote to, my lord, this member of the consultative committee, Parliament, Union Parliament. And the member of Parliament, being a member of the consultative committee, wrote to the these IOCL. And when the response came, the response was issued on 20th of May, and they also opened the bid or the technical summary on 20th of May itself, where they treat these particular bidders as qualified, technically qualified bidders.
That's what I'm telling, because last date was the 13th.
Yes.
April.
Right.
So 14th was the technical bid was open.
Yes.
Technical bid
Right,
was
right,
open
right.
and found they are qualified. They are
Right.
the financial bid on 20th May.
No, they opened the technical bid on 20th of May. Technical bid summary was title. No, sorry, 20th.
This is summary prepared.
Summary prepared.
Summary
Yes, yes.
prepared, but the open on
20th of May. 20th of May.
Second day it was open.
Right.
And the financial, when the financial bid was open?
Financial bids were 4th June. Right.
So on 14th of April, so they found all the documents were intact and they allowed.
Financial summary.
No, that's correct. But at the time of
may I just give you, lordship, the correct dates?
At the time of
I'm sorry, my lord, I stand corrected. My lord, 20th May, the tender summary report, when it was issued, the financial bid was also opened. And on 4th of June, my lord, the letter of acceptances were issued.
That's big. See, once the tender document was submitted last date on 13th April. So 13th April onward, you cannot submit any of the bidder cannot submit any document. Correct. So, and as per your submission, the invoices of 11th April, but the RC book has been this smart card has been generated on 8th,
right,
and RC is issued on 9th.
Right.
Correct.
Right.
So before the if the invoice is after that, how the registration has been done? This is your case.
Yes, and how, my lord, they could have the particulars given in the bid, therefore, are inaccurate.
So then, yes. What is the instruction?
Yes. One of the kindly sees the pre-qualification criteria ones, which my learned senior friend has placed already. Page 25.
You are for the ISC.
Yes.
Yes. Page 24.
Page 25.
Yes.
So this is the pre-qualification criteria. Now, two documents which are required to be placed along with the bids has been mentioned here. Serial number 3 and serial number 4 in support of each and every tank truck which has been offered. One is RTO registration. Either it has to be under Form 23, which is a physical copy, or 23A, which is a smart card. And then the calibration certificate. There is no provision for submission of any invoice, because invoice is a lookout of the concerned RTO
Yes.
before issuing any registration certificate. So the criteria was for submission of two documents. One is registration certificate, RC, and the other one is the calibration certificate. Now, so far as the successful bidders are concerned, everybody has submitted registration certificate as well as calibration certificate, which is the requirement. I have those documents, I can place those documents. Now, Ulysses kindly sees next clause 10 at page 28.
Yes. Yes.
Now, may I explain the process, how it happens? When a technical bid is open, then all the documents, the bid documents which were submitted are duly verified to some extent. Now, after verification, then LOA, financial bid, then LOA is issued. Now, after LOA is issued, each and every bidder has to physically place the tank truck at the IOCL's location, as well as all the documents in original for verification of those documents. So at the time of technical evaluations, whether document is authenticated or false, there is no scope. The only thing that is to be verified is there is a RTO registration certificate has been placed with the technical bid. Whether the registration, we will see whether the registration number is valid or not as per the RTO portal. That we check at the time of technical evaluation. That is what is provided in clause 10. May I please, ma'am? There will be no verification of RTO registration documents at the time of tender evaluation. The parties will be selected on the basis of the information submitted by them in tender document. RTO registration will be verified by state office before issuance of letter of intent. Please note that in case it is found that the information submitted in the tender document is not correct, suitable action as deemed fit, hence bidders are advised to submit correct information in the tender document. So before issuance of the LOA, this RTO document will be verified through the portal. How it will be verified? That the portal, the registration number will be placed, and it will be we will find that whether there is that registration exists or not. Now, my learned friend already placed the clauses. May I place those clauses again at page 54, my lord?
Yes, that is the subsequent. If it is found forged and all these things.
Yes. Now, consequences. What will happen after
Yes.
that? Kindly see page 55 once. From clause 19, 20 and 21. If any LOA is cancelled,
Yes.
to make up the shortfall or any additional TT requirement, post finalization of the tender, additional LOA to be issued from pending technically qualified L1 bidders as per seniority in the waiting list. Then 20. If a need for additional TT arises post tender finalization, the tank trucks will be inducted in the following order: induction from technically qualified L1 bidder waitlisted bidders, then induction through UOI, and then induction through public UOI. Then 21. In case of induction against cancelled work order or LOA, TT from the same category bidder shall be inducted from the waitlist. However, in case of non-availability of same category tank truck, induction of tank truck shall be carried out in line with allocation criteria of original tender. So in case in future, if it is found that any document is forged or any information is information submitted with the bid is incorrect. In that case, there is a provision for termination, cancellation of the contract, even if after a contract is executed. Work order and post work order of formal
So what is
contract.
the stage now?
Now LOA has been issued in cases of each and every
After
one.
the inspection.
Now inspections are going on. So far as two
After
parties
the
are
inspection. Because
physical inspection.
LO is to be issued after the inspection.
Yes. Only the inspection of the document which has been
Correct.
provided.
Document.
Not physical inspection. Like the authenticity of the document will be at the physical inspection stage.
Correct.
Not so far as two private respondents are concerned, that is respondent number
No.
14.
If you come to the page 28, clause 10,
yes,
the parties will be selected on the basis of information submitted by them in the tender document. No problem. RTO registration will be verified by the state office before issuance of the LOI.
We have done that.
That's why I'm asking. So LOI, you have completed the verification.
Yes.
RTO registration will be verified by the state office before issuance of LOI.
Yes. So we have verified that.
Then
now, so far as respondent number 8 and 14 is concerned, we work order has physical verification is also complete and work order has been issued.
Yes,
and so far the other private respondents are concerned, LOA has been issued, physical verification is still under process. After physical verifications, everything is found to be correct, then work order will be issued. Now, so far as the criteria I have shown to your losses, that two documents are required to be submitted. One is RTO registration and another one is the calibration certificate. There is no provision for submission of any invoice. So we have no occasion to consider any invoice or to verify any invoice. So far as verification of invoice is concerned, it is the duty of the concerned RTO who issued the registration certificate. Now the RTO will be in the better position to concerned RTO will be a better position to say whether the registration certificate which has been issued by the concerned RTO is authenticated or not, and on what basis they have issued.
Okay.
And I can
to whom you have issued the LOI?
LOI has been issued to all.
Verification is completed with respect of
8 and 14.
8 and 14 completed.
Yes.
But in respect of
no, work order has not been issued.
Okay. Yes, Mr. Bhattacharya.
May I place those work orders which has been placed, which has been issued already?
No, not required. Yes.
the facts of the case are so good, Manan, my client, but I will be joining hands with Mr. Mujumdar, but I will be also praying for an interim order as he has prayed for, only subject to the condition, my lord, that the report be submitted before your lordship, my lord. And my lord, in the event, the allegations are proved to be false, my lord, they be settled with cost.
Yes. I'm open to that. Yes, I'm open to
I
that.
have placed, my lord, all the documents,
Yes.
there is nothing to hide.
That's a fair stand.
But Mr.
No, I have all the documents already. My lord is having a set, my lord, all the eight tank trucks. My lord, may kindly take a note of the pro forma invoice. There cannot be any registration unless and until, my lord, there is an invoice. The invoice is there before your lordship. The second allegation was that it is 28 KL, the capacity of the tank trucks, but we have been considered for 35 KL. Since Mr. Mujumdar is here, he thought, well, it is prudent not to raise that point. The calibration certificates are
Mr. Manjanda, your client is also participated in that.
Yes.
But that is
My client has been technically qualified.
he has been set up. I'll show that also.
LOI issued, no.
LOI issued because the
number
price
81.
bid, my lord, we have failed to.
Serial number 81. The unsuccessful bidder taking a chance. He was not even, my lord, aware. Now he has been set up by someone who had approached, my lord, an honorable member of parliament, my lord, who is based out of Bihar. Now suddenly we find, my lord, that the person who is actually behind the scene, now he has addressed the representation to the concerned honorable member of parliament. It was in public interest. Now the petitioner here, he pleads that no, he acted as his attorney.
Yes.
Nowhere it is borne out from the letter that he was acting as his attorney. It's a new case, it's an afterthought. And now to stall, it's basically a cartel, my lord, which operates. And they keep on, my lord, filing cases, my lord, once they find, my lord, that someone else is getting the tender. I have all the documents and the entire set, my lord, of the clients, my lord, that I am representing. Even, my lord, even Form 2B. Form 2B also, my lord, it is an auto-populated form. Revenue, my lord, I am severely deprived of knowing, my lord, revenue laws. Mr. Mojumdar is there, my learned junior is there. He is an expert, he is a learner, so he has helped me out. It's an auto-populated form. No one can have any control. It will be seen whatever they are alleging are far from the truth. And my lord, we are ready and willing, my lord. If my lord directs my lord compliance with clause 13 and 14 of the tender conditions, my clients will be more than happy. However, my lord, some exemplary cost, my lord, should be.
Yes, my lord, I stand. My lord, that is the exact matter. But Mr. Majumdar, you tell me one thing. Okay, you main contention with regard to the invoice. Invoice is the
Right.
after
Even invoices have been
registration
issued prior to the issue,
registration is
subsequent to the
but
issue.
but the IOC has to see with regard to the registration certificate of the vehicle in question and registered owner of the vehicle in question. Correct. So as per the submission, what is the good name? I forget.
Amit Nag, my lord.
Yes. As per his submission that they have verified some of them, and after verifying they are issuing the LOI.
Absolutely.
And it is also your admitted case, the RC is there.
Yes,
RC
RC
is there.
RC
Is there. If the RC is there in ownership and the vehicle number is there, so with regard whether how it has been registered and not registered, then the inquiry can be initiated, and if the transport authority find inquiry some FISI has been done by the before the registering authority, or the document which they have produced, the invoices of the which they are producing of 8th April, and the document which you are relying upon the 9th April, that is some manipulation of fraud, the law will take its own course.
Only one submission. Just a quick reply to the IOCs. So far as Mr. Bhattacharya's submission is concerned, that is what I said during the course of my conference, that if your statement is correct, the honorable court may be with you. If your statement is wrong, be ready to bear exemplary costs.
Correct.
Exactly what I told during the course of last conference. Kindly take, my lord, clause 10, which, my lord, forms the sheet anchor of the submissions made by IOC. May I read out clause 10 for once? Page number 28. There will be no verification of RTO registration documents at the time of tender evaluation. The parties will be selected on the basis of the information submitted by them in tender document. RTO registration will be verified by state office. That means by the state office of IOCL before issuance of letter of intent. So, before issuance of letter of intent or letter of acceptance, some kind of inquiry has to be undertaken. Please note that in case it is found that information submitted in the tender document is not correct, suitable action as deemed fit. Hence, bidders are advised to submit correct information in the tender document. Kindly, along with this, kindly take, my lord, the letter of IOC addressed to the honorable member of parliament. Kindly take paragraph 3. How IOC, being the author of the tender document, it is been the author of the tender documents, the interpretation so given by the author would have some bearing. Paragraph 3. It is clearly mentioned in the tender document that the registration of the RTO shall be verified before the issuance of letter of acceptance. If at any stage documents are found to be forged, or if the information that has been given is found to be false, then the concerned bid shall be rejected and proper action shall be taken as required. So, whatever inquiry they must have undertaken at the level of state office, the inquiry does not reflect that the inquiry, the scope of inquiry extended to, my lord, the age of the vehicle, which is a criteria, it cannot be below 14 years. And also, my lord, the time of registration and, my lord, the actual acquisition of the acquisition of the vehicle. Because, my lord, the criteria is there that I have to be at least
No,
owner.
acquisition, where the acquisition?
Yeah, owner, my lord, kindly take
Yes, acquisition, that's why ownership. So
ownership.
that's why, see, as per the document which you are relied upon, as the document shows that the smart card has been generated,
Right,
RC is issued,
right,
it is the registered, there is no difficulty on that.
Right.
Only now the question with regard to the invoices which they have relied upon,
right, right.
on the basis of which the registration has been done, the invoices are the back date, first,
ওই একটা দেখা তো
subsequent date,
submit
and
করেছে।
the registration is prior date.
Yes.
Correct. So
Right.
that how the IOC will be concerned on that. So that
মানে
you can only pray for the inquiry with regard to this. If the state, if the RTO will submit the report, yes, there was a fee, then you can take appropriate action.
Kindly take one document, my lord, subject to lordship's kind
So
consent.
here, address the letter to the chief vigilance officer.
Kindly take, my lord, one document. This is the bid submission confirmation. This Durgapur oil carrier, এটা রেশমা number কত? Page 225.
225.
Yes, yes. First, my lord, kindly take page 224, where I have indicated that the invoice dates are 13/4/26. Registration date is 9/4/26.
Yes.
Lordship has got that?
Yes, yes.
Kindly take, my lord, when the bid has been first submitted.
225.
That is, kindly take page 225.
Yes.
Your lordship will find that the bid has been first time submitted on 6th of April. That is even prior to registration, no doubt about it.
Where you getting?
Kindly take, my lord, bid submitted date and time.
Page 225.
Yes, my lord.
Yes.
Bid information, tender title, then after bid submitted date and time, 6th of April 2026, 11:05 p.m. Now, my lord, your lordship has got that?
Durgapur Orgar, yes.
My lord has got that?
Registration date.
Your lordship will find the registration date being 9. No doubt about it. Then what they did, realizing that
This has been done.
that this is they have basically had been too adventurous, they resubmitted the bid on 9th.
It's not permissible.
That would be evident from page 226.
The 9th is date of registration. 9th April day again.
But the cartel is otherwise.
226.
Kindly take 226, resubmission history.
Resubmission history, bid document resubmitted 9th April.
So, my lord, then on 6th of April, he makes the first submission, submits the bid. On 6th of April, admittedly, did not have any registration certificate. 9th of April, he realized that he has been a little more adventurous. 9th of April, again bid submit.
No, that's a bid 225 with regard to the bid submitted.
Right.
Date and time.
Right.
And with regard to 226, bid document resubmitted. Document might be submitted subsequently.
My lord, that is, my lord, kindly take. My lord, if that be so, I put the question to myself with all humility. When a bidder is submitting its bid, my lord, obviously, my lord, it has to be accompanied by
All
documents.
RC and calibration.
And RC and calibration must, as per Mr. Nag, as well as per Mr. Bhattacharya. So, my lord, on 6th of April, whatever they submitted, that was not correct. And on 9th of April, they submit the bid documents. Evidently, my lord, the RCBs were generated on 9th of April. And my lord, he has been held to be.
You cannot modify. Change.
Kindly take, my lord, their own the bid document. Just 1 minute. So, my lord, what I am trying.
Page 53. Tenders not.
My lord, kindly take clause 6, which I read out at page 53. My lord, the tenders not meeting the tender terms and conditions or incomplete in any respect with any additions or deletions or modifications. We are liable. Summarily rejected without any further communication to the tenders, and the decision of IOCL in this respect shall be final and binding. So, my lord, 6th of April they submit. 9th of April they get the RC, they again resubmit. So what was the document which I put the question to myself, what was the document which was submitted on 6th?
No, that's, see, but they have not opened the tender. Tender was open, the technical bid was open on 13th. Before 13th. The last date was 13th. Till 13th, whatever the document after the opening of the tender, this is
Well,
not.
I bow down to your lordship's observation. I bow down to your lordship's observation. But my lord, having regard to the fact that the initial bid was submitted on 6th, my lord, whatever inquiry the tender committee or my lord, the employer in this case being IOCL, before issuance of LOA, at least this amount of this angle of inquiry should have been undertaken. That what were the documents which were submitted on 6th? Whether the documents are my lord.
Mr. Majumdar,
But it is an exercise which they have to undertake. I'm not.
That's why the tendering authority, while the first, when they will open, they will take all the documents of the from bidder and they will evaluate and find that it is, then they will make the charge whether it is rejected or it is.
Right, my lord, absolutely correct.
So though they have submitted on 8th, subsequently on 9th, but on the opening date on 14th of April, it was found that documents were there, so they have taken into consideration.
But the documents which were, some documents have been submitted along with my lord, the bid on which was submitted on 6th.
Yes, correct.
My lord,
I'll clarify that, my lord.
Correct. So that's why this is the online.
Is online.
Online. It
Right.
will be online, so automatically it will go to the bid section only.
My lord, when we file any form online, my lord, we go page by page. Your lordship, we all know that, my lord. In fact, but when we attempt to upload, if we skip the any page where some document is to be uploaded, the form is incomplete. The document at page 225 clearly indicates that bid was submitted.
Correct.
So, my lord, it was not a incomplete bid; it was a complete bid.
Correct.
So, my lord, it cannot be the case of the bidder or IOC that on 6th of April 2026, my lord, the RC was not submitted.
Correct.
Then, my lord, I put the question to myself: what was the RC about? There could not have been any RC on 6th of April.
There might be how many? I don't know how many RC has been submitted on that.
My lord, they have to place the maximum number of vehicles one can place is 8.
Eight.
He has placed 8 vehicles. All RCs were obtained on 9th of April.
Okay.
Okay. Yes. Just respond, since Mr. Majumdar said that he was responding to Mr. Nag.
Yes.
But he once again wanted to re-argued the case. But the set of documents, so far as this particular transporter is concerned, I have furnished that it contains Form 2B of the GSTR 2B, which is auto populated.
And that is not a necessary document.
Malord will find.
Likewise.
Malord will find everything is in order, and what they are alleging is far from the truth. Secondly, Malord, their allegation regarding resubmitting bid, but there is a condition that in terms of preference, newer vehicles will be given more preference in case there is a tag. That's like I got my newer fleet. The fleet of vehicles, my lord, which were quoted. Thereafter, my lord, will have the dates, my lord. When, my lord, I got the registration certificate, my lord, and the invoice. I, my lord, supplied the details of the newer vehicles, my lord. That is the resubmission. But my lord is absolutely right with the observation that it cannot be modified once after it is.
That also.
I reiterate, my lord, for the sake of prolixity, my lord, I will not stand in the way if my lord directs compliance with re-compliance with clauses 13 and 14, my lord. Subject to the humble condition, my lord, that I was.
Well,
that
so far as
case, my lord.
only my humble submission is, so far as the process is concerned, it should not be stalled. There can be
Should not be
stalled, my lord. That should not be stalled.
Let it be stopped for some time.
Let the inquiry be completed.
It is the sentencing RTO who has to conduct the inquiry.
Merits, my lord, that I am not in my typical self of my lord.
Well, only one submission.
Mr. Majumdar,
Yes.
can I take the advisory jurisdiction here? It is better to make the RTO party here, then the court can pass an order to submit the report.
May I just make one humble
Just only 1 minute time. RTO party হলে আমার রোজগারটা চলে যাবে। Then clause 13, physical verification after issuance of LOA which has been in favor of my client, that is 12 and 13. We got through, there is no red flag whatsoever. Only the allegation. Allegation cannot be sacrosanct. Twice verification has been done, we got through.
Yes.
Well, only
Thank
one
you.
submission, my lord. We have made National Informatics Center as a party. But lordship, I beseech your lordship, whatever, I am seeking an interim protection to some extent.
What is the interim protection you ask?
What the interim protection that I asked, today they have issued LOA yesterday. In fact, sorry, yesterday they have issued allotment order or work orders with respect of, I think, 2 or 4. I don't understand.
You are the unsuccessful bidder.
Yes.
Serial number 81.
You are the unsuccessful.
I am the unsuccessful bidder, but my lord, it is not that I am approaching this honorable court, my lord, at a belated stage. But I registered.
That's correct. That's correct.
But only one submission, my lord. Whatever may the process may go on, my lord, this is a service contract. In a service contract, your lordship knows better than us. Unlike, my lord, an infrastructure project or something like that, my lord, it may so happen that at the completion of the hearing of writ petition, I may succeed. So, lordship will kindly give me that protection.
What?
For the period for which, if they are allowed to function, if they are allowed to operate, my lord, if finally it is found by your lordship that, my lord, my contentions are correct and their contentions are not correct, incorrect, then, my lord, that period should be added back.
You're right.
Yes.
Your serial number 81.
That's what I'm telling. That's why. What you making the prayer? If suppose yes, you are the third one on the waiting list,
yes,
and because of this you could not get, then you can be revert to the first one.
This is not that, my serial number.
No, if suppose in the waiting list as per the
Yes,
condition,
let them do that.
You are in the waiting list, and because of this you could not get, and they will be out, then you will get. Then
I
okay, you
understand,
can be reverted to the number one.
Chronological sequence given in the bid summary report or the tender summary report, but is not indicative of my wait list. Is not indicative of the wait list.
But Mr. Majumdar, let them file the report.
Let them file report. My lord, kindly then make it returnable. Let them file report before lordship.
Let them file the report.
And in the meantime, my lord, and NIC should also file report. My lord.
What the NIC will do?
My lord, the submission times, everything, the documents which were actually uploaded.
They are the master server.
They are the master server.
Who is appearing for the NIC?
We have served. We have served.
Previously, someone from the union used to represent. But I was there, I used to represent.
NIC is
this time you cannot.
I cannot. Please don't add the RTO. Then I have to go there.
The RTO তো এখানকার RTO নয়।
না না এখানকার RTO।
আচ্ছা এখানকার RTO নাগাল্যান্ড সব নাগাল্যান্ড।
Challenging the order process issued by the Indian Oil Corporation Limited for
নাগাল্যান্ড
for road transportation of bulk petroleum products, black oil X location / Haldia refinery terminal. Not concept for that as per pre-qualified criteria, the maximum TTs to be offered, 5 numbers of TT to be offered, out of which minimum 3 should be owned. 3 should be owned, and the RTO registration and the self-certified copy of the registration certificate within bracket form 23/23A to be submitted for each offered TTs within bracket and TTs tank truck within bracket herein after called as a TTs. Full stop. The bidder should also submit the maximum 5 compartments with tank carrying capacity of 18, 20, 24, 26, 28, 29 KL to the maximum 35 KL. Full stop. Self-certified copy of calibration certificate issued by the legal metrology mentioning compartment to be submitted for each ready-built TT offered. And counsel for the Mr. Majumdar and senior advocate appearing for the petition submitted the maximum numbers of the TT that can be offered by the bidder is 8. The main grievance of the petitioner in the present application that the bidders who have participated in the said tender, they have purchased the new trucks, new oil tank, and as per the invoices, the date of oil tanker is after, and the date of invoice of the oil tanker is after the date of registration of the vehicle. He submit that, and thus he submit that without the invoice, the vehicle cannot be registered. Thus, registered fully. He further submit that in reply to the letters of the Honorable MP of the Lok Sabha of Valmiki Nagar, Bihar, the Indian Oil Corporation has sent a reply to the query raised by the Honorable MP, wherein it is mentioned by the IOC that in the tender document, the registration of the RTO shall be verified before the issuance of the letters of acceptance within bracket LOA. Full stop. If any stage, any documents are found to be forged, or if the information that has been given is found to be false, then the concerned bid shall be rejected and proper action shall be taken. Mr. Majumdar further brought to the notice of this court one of the document of the Durga Oil is the respondent number of Mrs. Durga Oil carrier, and submit that the said firm has submitted the tender submitted the bid on 6th of April 2026 at 11:05 p.m. But subsequently, on 9th April 2026 at 8:41 p.m., he has further submitted the bid document, which is not permissive. Which is not permissive. Mr. Majumdar further submit that as per the tender condition, the tenders not meeting the terms and conditions of the tender or incomplete in any respect or with any addition, deletion, or modification are liable to be summarily rejected without any further communication to the tenderers, and the decision of the IOC in this respect shall be final and binding. But in the present case, the IOC have not complied with the terms and conditions and accepted the document submitted by the tenderers after submission of the bid document. Full stop. Learned Counsel for the IOC submit that as per the bid document, there will be no verification of the RTO registration document at the time of tender evaluation. The parties will be selected on the basis of information submitted by them in the tender document. The RTO registration will be verified by the state office before issuance of the letter of intent. He further submit that in case if it is found that the information submitted by the tender document is not correct, suitable action as deemed fit will be initiated against the tender. Land Council appearing for the IOC further submit that after verification of the RTO registration certificate at the time certificate, only after verification of the registration, the LOI has been issued, some of the tender and further issuance of the LOI is under process. He further submit that with regard to the what document the tenders have relied upon at the time of registration is not the duty of the IOC to see. The IOC has only to see whether the document which the tenders have applied for have submitted. The IOC has to see the document which has been submitted by the tenders having the registration certificate of the said vehicle, which vehicle is to be used for the transportation of the product. Now you're as a council, not the AG. Mr. Bhattacharya, occurring for the respond number?
I'm representing the respond number 8, 10, 14 to 17.
8, 10, 14 to 17 submit that the said respondents were having sufficient document to establish that they are the registered owner of the vehicle, and as per the invoices submitted by the said bidders, the registering authority have registered the vehicle, and after verification of the documents submitted by the respondents, the IOC has issued is under process for issuance of the LOI. Yes, Mr. Sonsu appearing for the respond number 12 and 13 submit that the respond number 3 and 13 we are also having sufficient document to show that the said vehicle which has been put in the vehicles of the respondents have been registered in their name, and the respondents authorities and the IOC have satisfied with the documents submitted by the respondents, and as such there is no and as such the submission made by the council for the petitioner cannot be taken into consideration. He further submit that after the opening of the tender, 2 rounds of the verification of the documents has been carried out by the IOC and found that the vehicles is registered in the pair of the respondent. The council for the respondent submit that prays for time to file affidavit in opposition. Heard the learned counsel for the respective parties. This court find that the only grievance on this court find that the grievance of the petitioner in the present writ application is that some of the vehicle which is the subject matter of the tender, the invoices is the subsequent date from the date of registration. And some of the firm have submitted the bid document, but the date of registration of the vehicle is subsequent, and they have submitted the document subsequently. It is the further case of the petitioner that if the vehicle has the invoice is invoices is the subsequent date of the date of registration, how the registration has been done without the registration or without the invoice of the concerned vehicle. Considering the above, this court find that as per the terms and conditions of the tender, the IOC has to see whether the firm who has participated in the said tender having the vehicle registered in their name, and they have to verify with regard to the documents of the registration document of the respective vehicle, whether the vehicle has been registered illegally or not in accordance with law is not the duty of the IOC to see at this stage. This court prima facie find that the document which the private respondents are relied upon for getting the LOI for supply of the TTs, they are the registered owner of the vehicle in question. And the IOC are verifying the registration certificate of the concerned vehicles. And as such, this court finds that at this stage, the petitioner has failed to make out a prima facie case to pass any order of pass any interim order. Accordingly, the interim order is refused. Full stop. The IOC and the respondents are directed to file affidavit in opposition within a period of
Some urgency, my lord. Some.
within a period of 2 weeks.
Yes, my lord.
If
Yes.
There are altogether 9 private respondents whose documents has to be.
Well, they are giving
Some more time.
clearance one by one, already given clearance to most of them.
within 3 weeks, reply if any dare to be filed within 2 weeks.
Well, 1 week. 1
1
week.
week.
1 week.
1 week is the matter on
Kindly give us a date and time, others.
on time. Then अगस्त में कब है?
अगस्त से था.
जुलाई में है. जुलाई में लास्ट में देखो 30
Any time, my lord. Any time, subject to lordship's wish.
1-2 बजे. जुलाई में नहीं है, अगस्त में कहा जाता है. जुलाई में June 30th जुलाई. अगस्त में देखो क्या डेट है. 30 जून का 30 जुलाई का बाद. At 7th August at 12 noon.
So they will file a report. IOC will file a report or affidavit, my lord.
Affidavit, let them file affidavit because the report then it is not on.
Yes. Better.
Respondents.
Grateful. Grateful.
Yes. Take the book.
So, but my lord, the cost will be either ways, my lord.
Mr. Mojumdar fails to realize I am a good man. I supported it. I paid for an interim order.
But next matter, item number 17. Your lordship has a fixed matter now at 1. But can it be not today, my lord?
Which one?
17, item number 17.
17.
Tomorrow I'll do the matter
You
tomorrow.
are for the?
I am for the state.
Who is for the petitioner?
17. But now there is a fixed matter.
But during the tendency of the repetition, there is a development.
Yes,
Your
lord.
lordship kindly see. Lord,
The representation has been considered and 3rd of July is fixed by the commissioner, my lord, the excise commissioner, my lord, for hearing. For hearing. So in view of that, it can be disposed of.
Lord, will not your lordship kindly take note that judgment of the honor, at the time of mentioning what I've said, the 2003, 2003 page clause.
So what you want? Okay, let come tomorrow.
There is a fixed on the date fixed on
9th of?
9th of
No, 3rd of
July. 3rd of July.
3rd of July.
3rd of July. 3rd of July. But I have no objection with my landed estate with the commissioner. Commissioner can, but not your lordship, because vehicle cannot, because I am not.
Okay, you do one thing. I am only passing an order. Let it be kept pending. The commissioner is at liberty to take appropriate decision pending report.
But because the cause of action, your lordship knows, they have challenged, but their grievances. The commissioner has not considered our representation.
No,
that has been
not only
considered.
that, not only that. I say not vehicle cannot be withered, cannot be detained for a long individual.
Well, it is like
Because
Forest Act,
knowledge-
Excise Act also your lordship knows.
Excise Act-
It is solely let it be tomorrow, I will not waste your lordship's time.
On 3rd of July, let him take a decision, your lordship.
Okay, I am fixing after 4th.
Yes, after 4, on 4th.
You see matter. It is submitted by the land council for the petitioner that the petitioner has received a communication on 25th of June 2026 from the Superintendent of Excise, Bardhaman Excise Division, that the hearing is fixed on 3rd of July 2026 at 11:30 p.m. before the Additional Excise Commissioner, Bardhaman. In view of the above, the case is adjourned. Let the matter appear on 6th of July 2026 under the same heading. Pendency of the writ petition will not prevent the Additional Excise Commissioner or the competent authority to take decision in accordance.
The 6th is a state holiday. Let it be on 7th.
Acha, I said holiday. 7 July. Yes, call them fixed.
What holiday is there on 6th?
I don't know.
No, not yet decided.
Not yet.
But I'm for the Eastern Coalfield.
Lord, I appear for the petitioner, my lord. With your lordship was pleased to consider this matter.
After yesterday.
I did not allow your lordship to have lunch yesterday.
Yes.
No, my lord, here now, my lord, this is that matter, my lord, where, my lord, we could not upload the document, my lord, though we were within time. My lord, your lordship was pleased to invite my learned friends, my lord, both ECL and GEM to file their reports. The reports have come and, my lord, we have taken exception also. So,
Maybe place our reports, because from reports it will clear, absolutely clear that the default was not on the either on the portal or on us.
Of the respond number?
I am for the respond number 1 and 2. I am for 1 and 2. 1 and 2 is ECL. I have also filed a report. Yeah.
Your ECL.
And GM will also file a separate report.
Yes. Well, the GM's report is the main report because ECL has said what GM had communicated to them.
No, I have said one more thing. I have said that there is no allegation against us, so there can be no allegation against us for any malpractice in the tender. There has not been. So in that case, whether how under the order of court I am prejudiced from publishing a tender. In absence of an allegation against me. That's my stand I've taken.
Jamie's respondent number?
4. That report is also there.
Respondent number 4.
Yes. With the report of GM, my lord, your lordship will kindly find, my lord, this is an afterthought. Kindly take me at paragraph number 7.
I humbly submit
that in order to successfully participate in a bid, a bidder is required to complete each stage of the bidding process in the prescribed manner. In the present case, the petitioner was logged out of the system as it failed to complete a mandatory stage of the bidding process, as is evident from the video recording between 108 to 124. We are pausing here for a moment, my lord. The bidding process was up to 2 p.m. Therefore, I was there within time. Submitted by the petitioner to the help desk of the respondent number 4. Again, my lord, pausing for a moment, my lord. I had approached the help desk while, my lord, the bidding process was on. Then, the aforesaid video recordings is annexed, etc. It is submitted that the system is designed in such a manner that each stage of the bidding process must be duly saved before the user proceeds to effect final submission of the bid. As evident from the video recording submitted by the petitioner to the help desk of the respondent number 4, the petitioner accessed the upload document stage of the bid submission process. However, it failed to save the stage and instead proceeded directly towards bid submission. So this is the new case that is coming in the report. But I'll take your lordship through the contemporaneous exchanges that had happened around 2 p.m. on that particular date. Now kindly take, my lord, paragraph number 9. It is pertinent to note that compliance with save requirement is mandatory under the system workflow for duly recording the necessary inputs, documents at various stages of the bid submission. Since the petitioner did not complete this mandatory and implicit step, the system automatically locked the petitioner out, resulting in its inability to successfully submit the bid. The inability to submit the bid was therefore as a consequence of the petitioner's failure to correctly submit its bid and not due to any technical malfunction or deficiency in the system. My lord,
please proceed on the basis that whatever they have said to be correct. Now, what they don't deny is that, my lord, I had approached their help desk while, my lord, the bid was on, number one. Number two, the help desk or the support team had accessed my computer remotely in order to assist me to submit the document. I can understand that there is a default or, my lord, fault or glitch on my side. But in that case, my lord, the help desk people or the support people could have told me that you save it and go. And, my lord, it is, my lord, our common experience that if I have to save things stage wise, because I will not be allowed to go to the next stage. Like, my lord, buttons here, Lordship has experience, save and proceed. If the portal requires that I have to save each stage and then only I can go to the next stage, because the online system is to be programmed in such a manner so that without saving I cannot go, and the instruction also comes that you save and then proceed. This is the case which has been made out. Now kindly take my exception to this GEM's report. But can we come back on some other day, because I'll have to take some time.
Suffering an interview without any.
You are appearing for?
For ECL, my tender.
Who is for the other?
But I am for the government market placement. There is no fault on my part. No one has made any.
Who is for the private respondent is there?
No,
there is a private respondent.
But I have got a very simple prayer. Allow me to submit my document.
The procedure is ongoing. Lordship has directed me status quo that I am not publishing any. But
how many tenders are there? Further?
The exact figure I do not know, but more than 10. That's what I. But the exact figure I do not know right now.
No, you have stated that the save requirement is mandatory under the system workflow for the duty. So why?
May I have 5 minutes of your Lordship time to indicate as to what has happened?
No, in that case, may I finish? Then my
not kindly comes to their letter, their first complaint. That is at page
250.
Volume
352.
352, minute. Volume 2. It's written.
Yes, 352.
But kindly sees the email is being sent at 2:06 p.m.
Correct.
Kindly mark this.
Correct.
And they are saying, with due respect, we would like to inform you that we were trying to submit our subject bid today between 12:30 and 1:45 p.m. However, when we attempted to verify the OTP at the final stage of bid submission, the GEM portal automatically logged us out and redirected us to login page. The issue occurred repeatedly despite several attempts from our side. A screen recording of the issue is attached for your kind reference. We would also like to inform that due to technical issue with the GEM portal, we were unable to complete the online bid submission process, even though we initiated submission well before the actual deadline. In view of above, we kindly request you to consider extending the bid submission deadline by at least 5 days. Therefore, extension will enable us to complete the submit our bid properly. Now, my lord, so far as this email is concerned, admittedly, my lord, this is being sent at 2:05 p.m. So far as the bid timing was concerned, that ended at 2 p.m. sharply. Bid submission. Bid submission. Now, my lord, on the first email, they never alleged that they have taken any assistance from the help desk. Kindly cease. So, my lord, their contention that help by way of help desk, they were being assisted. That is, my lord, completely, my lord, wrong. That is, my lord, not even appearing from the first email which, my lord, they have sent to the GEM portal authority. Now, my lord, kindly says what is only replying, because when your lordship is well aware, when any ticket is raised, automated mail is responded to. That is, my lord, at next page 358 at 2:12 p.m. my lord, kindly sees that automated response is given, generating the ticket number. Nothing more than that. Only to that extent. Now, kindly see in page 359. 359, what we have stated, that is at 2:25 p.m. We would want to fourth paragraph. We would like to inform you that as we have checked, bid has already been ended. Also, there is no provision to extend the bid once the bid is ended. Your Lordship is well aware the bid is floated by the ECL authority, that is the buyer. If bid is required to be extended, that is exclusively in that domain. If the request us to extend it, we can do it. We are only the service provider, the platform, like Amazon. So proceed further accordingly on GIN. For further reference, kindly raise the concern along with the error page screenshot recording at the same time to expect the reason from our side. So we have not categorically informed them that bid is ended. At that point of time, we have not analyzed as to what went wrong. We have not said that it was the fault on the part of the GEM or it was the fault on the part of them. We have not analyzed. When we have analyzed, when your Lordship has called for a report that as to what has happened, they have given a video. We have also given a video. From the video, from the video, it would appear that when they were proceeding to the next step, they are not saving the application. And in the demo video, we have shown that if you are saving and proceeding, then the bid is getting submitted. So two videos I have submitted in a form of pen drive, and out of those two videos, one of is their own, from wherein it would appear that when they were trying to proceed further without saving, then they are getting automatically locked out. And this is not the first time. This is not the first time that they have appeared, they have participated in this tender. They have doing it regularly. They are well aware. And what they have not told before your Lordship is that on the same day that I have subsequently got, although I have not given in my report, on the same day, in respect of another bid, they have approached the help desk within the time when the bid process was on, and physically they have approached, and they have guided the petitioner to submit that bid, and they have even also got the tender. Now, so far as this tenders are concerned, they not approached. Petitioner was approached after the bid was not
This is
closed.
factually incorrect.
No,
This is
after
factually
also.
Because from the record that has been disclosed.
Where is your instruction with what you are telling that they have to save and thereafter
Yes.
go ahead? Where is the instruction from your side?
That is in the report, in the report submitted.
Prior to that,
Every
in the GEM,
kindly says.
so you have there is no guidelines how the online.
Your Lordship would kindly peruse the this video in the pen drive. Kindly peruse it. There is no instruction over there.
In the sample video, if your Lordship
I'll
if your Lordship says the sample video, in the sample video, it is shown that it has to be saved before proceeded further.
It's kindly peruse it, my lord. We'll assist your Lordship on that.
In that case, my lord, if it is absolutely between the petitioner and the GM, that is how it is appearing, my lord, then my lord, I am becoming prejudiced without any fault.
This court is the victim on that.
The Lordship is victim number 1 and the victim number 2. So we will kindly appreciate one thing: if there is any loss that the petitioner suffers due to a fault of GM, or that can be resorted outside the courtroom with in some other forum.
I do not
but
know
involving
why
that
ECL does not want me to participate. I have a very
I have
simple
not
prayer.
received his bid within time. He had 13 days to file the bid.
No.
13th May it was first opened. 28th was the filing last day. 13 days he had to file the bid. He did not. He chose not to do it on last day. And the last day after 2 p.m. he raises a complaint. This is for one. The other matter that he raised a complaint on the next day after the bid closing date. Unnecessarily I am being prejudiced. I am involved in
Your Lordship, he has any day convenient. I'll take about half an hour time, my lord.
Lordship, kindly vacate the interim order, allow me to publish the bid, and thereafter Lordship can resolve this dispute, can be resolved otherwise also. It's a completely private dispute with the petitioner and the GM.
My friend has not come up with any vacating application.
No, I am taking that point in the report itself.
And this is a contested vacating order. It's not that it is.
But I have taken that point. I have taken my report
My
itself.
learned friend can always file a vacating application.
अभी बीच में नहीं है देखो वही जुलाई में फर्स्ट में कुछ देखो नेक्स्ट वीक कोई खाली है पहले नहीं है
Publish
Learned counsel for the respective parties argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 10th of July at 12 noon. At a specific matter.
10th of July.
10th July.
Only one framework.
But the interim order may continue till then.
But so far the interim lordship has in paragraph number 7 of your lordship's last order dated 9th of June. Lordship has
10th of
asked
July.
directed to maintain status quo as the date with regard to the tender process. So the tender analysis, publication is one thing and analysis is another thing. Analysis also stopped on 9th of June. Lordship will kindly allow me to continue the analysis. I will not publish any result.
Well, let that be done on the next day.
Otherwise, I have to do the whole thing again afresh.
The respondent authorities are free to analyze the tender issued by the authorities, but not to finalize the tender till the next date of hearing.
And not to publish also.
Yes, I'll
Not to finalize.
Well,
Not to finalize the next date of hearing. That's it.
for this matter.
What is urgency?
Matter the urgency is it relates to a puja matter. Durga puja. It relates to a Durga puja matter.
Durga Puja, there is a, what is the urgency? 3 months?
Yes, my lord. Because the organizers have actually this model is trying to install the Ram Mandir. So at least 2.5 months are needed.
Huh?
2.5 months are required.
2.5
months are required, my lord. So they have applied, accordingly they have applied to the concerned authorities. They are still sitting right over the matter. So administration has yet to take any decision. So therefore, this is the urgency. It is a
urgency. The representation is pending and there is an urgency.
No, my lord. Actually, for the construction,
That you file it. What is the urgency?
my lord, the urgency is it's a
Before this court, the urgency meaning tomorrow you are going to be evicted. That is the only urgency. There is no urgency before this court. I don't know with regard to the other court.
obliged.
Court, there is urgency means if tomorrow you are going to be evicted or tomorrow you are going to be affected by any order, then there is an urgency. Otherwise, no. Yes.
Obliged.
Milord, I appear for the petitioner. But today, Milord, we have a very limited prayer for the extension of the interim order which was passed by the Honorable Division Bench. Now, Milord, your Lordship was in the circuit when, Milord, we had moved this matter before the bench taking up your Lordship's determination. Milord, initially, Milord, the Honorable Court, Milord, was pleased not to pass any interim order. But this is, Milord, on 18th of May 2026. Kindly peruse, Milord, the order of 18th of May.
Yes.
Milord, in paragraph 7 of 18th May order, Milord, Learned Counsel for the respondent seeks and is granted 4 weeks time to file affidavit in opposition, reply so and so. Milord, the matter travels to, Milord, the division bench. Milord, the Honorable Division Bench, Milord, was pleased to pass an interim order. If your Lordship may kindly take, Milord, page number 4.
Yes.
Para 11.
Should not be issued till the writ petition is taken up
Next. This interim order will not cause any prejudice
The
because
tending authority as the existing contract for the repair continues up to June 30 and the subject
Yes.
contract is
no, Milord, affidavits were directed in paragraph 12 or by the Honorable Division Bench, but I'm told, Milord, affidavit has not yet come. Both the orders are, Milord, contested orders. So, Milord, I was saying if my lawyer friend wants to file affidavit, Milord,
I'll pray for extension of time for further 2 weeks.
What about the interim order?
Well, let it be extended for a period of 3 weeks.
well, give us 1 week time to file our reply.
The matter is listed in the supplementary list for extension of the interim order. And counsel for the petition submitted initially the coordinated bench of this court refused to grant interim order. Accordingly, petitioner has preferred an appeal before the appellate court. And by an order dated 21st of May 2026, the appellate court has granted interim order, which is existing till today. Will say further submit that in terms of the direction passed by the Honorable Division Bench, even the coordinated bench of this court, the respondents will not file the appeal in opposition. Counsel for the respondents prays for time to file appeal in opposition. Let appeal in opposition be filed within
2 weeks, Lord.
2 weeks. A reply, if any, there to be filed within a week thereafter. This is the matter on on 30th July 2026. Under the same heading, interim order is extended till 31st of July 2026 or until further.
Well, only one request for that. The Honorable Single Judgment also directed affidavits, and the Division Bench also directed affidavits. But there was an additional direction in the Division Bench's order that the documents of the private respondent is to be disclosed. Therefore, kindly would add 2 words, Milord, that affidavit of opposition in terms of the Division Bench's direction.
That is also, we definitely will comply with the direction of the Honorable Division.
So, yeah,
Where is that? Where is the order? The division bench?
Oh, then I think this did not go down in the order. Whatever is there.
Okay, let the file.
Yes, page 4 top, page 4 top. Or page 3 last 2 lines. Moreover, this issue can only be clarified upon the affidavit being filed, enclosing the entire.
It is made clear that at the time of filing of the affidavit in opposition by the authorities, the authorities shall disclose the entire set of the documents which were uploaded by the two bidders who had technically qualified in terms of the division bench order. Technically qualified in terms of the division bench order dated 21st of May 2023.
I'm grateful.
On 30th July.
Huh? 31st and 30th July. Interim order till 31st.
31st.
Which matter?
This matter.
Puja matter?
No.
Ah.
It's a different matter. Similar order can be passed out.
Which matter, sir?
This matter is not a listed matter.
This matter means I don't know which matter. Ah.
My matter is also similar matter which pertain to a similar tender. Similar order can be passed.
Come tomorrow morning, Thursday morning, or not is at this stage. Yes, call the call.
But I appear for the respondent number 6 in this matter.
I am happy.
There was a direction of exchange of affidavits. My affidavit was affirmed on 21st of May 2026. But inadvertently, my lord, we forgot to serve this affidavit in opposition. Today only, my lord, we have given them a copy.
Have you received?
And I'm praying for lordship's leave to my lord to file the affidavit. On behalf.
So you are filing reply also?
I replied to the affidavit filed by
Respondent no 125.
affidavit file kuru. Department of
So you will file reply.
My junior is also. We can argue without the reply. That will be subject to one doesn't or filing a supplementary affidavit.
Subject to correction, I have not received the copy.
Nothing, it is nothing. It's a copy of the Panchanama which has been prepared by them. It's nothing more. Just to bring it on record. The Panchanama which has been made pursuant to the orders of the division bench. Which they have relied, they have also disclosed. I'm just not recording my no. But I don't think my learned friend may have some once against my late filing of this application.
Yes.
They begin this matter. Not have a right of compensation which has been held by the EDMLR against this order passed by Lordship. They are bringing a qualified order and takes
125 is for. Yeah. আচ্ছা চলে এসছে ফাইলটা আচ্ছা
Yes, got it, got it. Yes. Yes, 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 yes.
But after this, was service. Thereafter, and the question corrected again the team. And also the there is one very coordinate. There is a ADML, which is additional customized ADML, and one is a special layout. Both are not the same purpose. Who is authorized and who is not authorized, I will lay down their notification. Also to the order, also to the set. Now, not all the parties, all the three parties, they arrived on the date. There was a joint survey and a Panchama was prepared. So Rational comes to the first prayer of the repetition. Rational see the first prayer of the repetition for all practical purposes have been done. Exactly.
Yes.
But all the parties they have prepared what should be the orders of the division bench. They have prepared the motion.
Correct.
The player A has been granted by the other they would have so they have somebody to now the next issue you are seeking this okay. I'll read. But there is another absolute fact which is it is after the person orders but opportunity has not been prepared in terms of your lordship they took possession of the fishery and they dewatered the fishery. Whether the question will be of A, that is not going to be experiment which is happened before. And they gave it the process of putting the catch of land, the process of ROE for the Bible. There are two things remain to be educated or whether the two note is where comes that is the ADM had correct to a conclusion that my class were not intended to composition whether that is correct or not. And if correct, then I am out of good. And number two, if I am entitled to composition, in my humble submission, it is a competent authority who is to decide the constitution. So, pursuant to your lordship, my cinema was being prepared. Two aspects came to forefront. One was that there was a particular order of land which was recorded in the first class. It is with your agree. So we made a prayer on 15th of May, 15th May to the Constitution Authority that this calculation is here.
Calculation? Calculation?
Calculation of the area of land in which there was a fishery is incorrect.
Okay.
So what was granted was 17,709. 178 years.
So what is your claim? Your claim is that
more than 209.
No, what is your claim? Your claim is that you are the owner of the property or you are in occupation of the property.
I am a lessee. Owner. I don't claim myself.
Who is the owner?
Now, the owner is persons who are the assessors. Now, the owners were granted acquisition compensation. There are two aspects. The acquisition compensation is done for the provisions of this act only for the purpose of acquisition of the land. And the right of usage is another aspect. So far as the acquisition of land is concerned, payment of compensation, we are not important to whom this compensation should be. And we don't make a claim also, we are not the problem. But insofar as right of user for the purpose of breaking of the pipeline is concerned, for which is act is coming. The compensation is to be paid on the basis of a Panchnama, which we prepared in terms of the order, terms of the act itself, the good thereafter. Specific rule 4A, 4B, 4A and 4B. Very, it has been clearly stated and there has been further fortified for addition to the order of this one. Panchanaama is an essential document on the basis where the compensation to be paid to the user of the land, the owner of the land. Owner may also be an user. But in our case, the owner of the license, on the basis of the license, you were entitled to loan of. I mean, 100 case was, that is 2022. Because of this. Ultimately, I am not claiming. Because there at the point of time when there was an acquisition of the land. When there was an acquisition of the investment, there is a whole bunch. Now, for a pipeline to be put in place, one does not require the entirety of it. It is only the width of
The area which have been affected.
and the length and breadth. But at the same time, they acquire corresponding sites also, so as to ensure that there is no problem in the course of the proceedings of the revenue in the matter. At that point of time, when our land was not the right of which was not being availed of in our portion of the land. In our portion of the land, they came to put in the pipeline in the year 2025. At that point of time, you were in place. When the paid compensation to the owners of the land for the purpose of acquisition of the land, we are not bothered. It is only when there is a user of the land, maybe the owner, maybe someone else, maybe someone or whatever. Till 25, there was no user of the land. I had a lease agreement with the landlord for a license, which I was permitted to have a fishing. And I was happy. Now the laws is not. But that's it. The next second story.
Any minute. Rule 4. Yes. 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 So these are the procedure.
Preparation of the Vaishnava at the very outset is the Sinkuma law. Or any ROU to be exercised by
That's correct. See, now in terms of the order passed by the Honorable Division Bench, the Panchanama is prepared. Now first you have to establish what is your right to claim compensation. Now.
I will now should The order dated 29th of
29 December 2025. Yes.
So the first point I would like to bring to your notice is whether ADMLR has got the jurisdiction authority to pass it. Honorable Lakshmanji, this is a committee.
Correct.
You Lakshmanji at page 1.
Yes.
It's a committee which is headed by the ADMLR,
Correct.
in which the special administrative director is a party. Honorable Lakshmanji, who is the competent? Lakshmanji, definitely party. That competent also is a person who is to be appointed for notification check.
Page. Yes.
Is a statutory requirement of a person to be notified in an official gazette to act in terms act as a competent authority. As a Lakshmanji, who is a competent authority in our
Yes. Yes. $78 of respond number. Yes. Yes. Hmm. Yes.
Only compare with the order of December, which is an authority to pass an order with regard to the petitioners permitted to pay compensation or not.
Yes.
Further, let me see the authority. Whether this committee was at all notified by an official gazette to act as a competent. Question of payment of compensation is to be passed by the competent, no one else. One cannot usurp the jurisdiction of the competent authority by putting in 5 more people I'll say, no, you're not. I got to put it in very close department. I'm only asking the question to myself as to whether or not the ADM is heading a committee was notified by the same government or not. Where the government? When admittedly, they have said the special land defense collector is the government authority and the special land defense collector is not the. So you have to see the purchase order not in its capacity as the special land defense collector or the government authority, but it was in its own capacity. There is any matter. And if it is
Land acquisition.
and he proceeds to treat the entire matter as if he has acted on the basis of a statutory authority. He may be an officer of the state of West Bengal, but he is not a statutory authority under the Act. Let us see the basis on which the NMLA has proceeded to deal with case of the petition.
Yes.
Let us see the way my learned go through the entire. I have my first point is whether this order passed by the NMLA in its capacity not as a competent authority to decide whether or not the petitioners were entitled to compensation or not, whether that is within jurisdiction or not. If it holds that the NMLA would not have passed such an order, then it ought to be disclosed in favor of the
Yes.
number two things. Let's see the basis on which the NMLA is proceeded. Let's see. Let's see the members, so-called members of the person.
Which paragraph you have taken in the writ petition? Which paragraph you have taken with regard to the competency of the ADMLA? Which paragraph of the writ?
Assuming I have not taken.
No, then they have to give the reply to that. In which
No, we have responded to that. They have taken it, my lord, that he is not the authority, and we have responded to that. But my learned friend says that they are not filing my reply to my affidavit in opposition, my lord.
That's what I'm asking.
They are not traversing my contention in the affidavit in opposition. But I have dealt with it. I've specifically dealt with it.
In a very 5 minutes time he could.
Specifically in paragraph 11 of the writ petition, they have taken that point that he is not the competent authority. আমি কেন করছিলাম আমি প্যারাগ্রাফ 8 এ ডিল করেছি and in paragraph 8 of my opposition malad at page 12 I have dealt with it.
Because whether or not under section 8 it can be applied or not, and there is also something which you forgot.
through my affidavit in
Yes. You could have been say you have argued the matter at about 40 minutes. Now you are asking for the reply. You have started your submission that you will not file the affidavit in reply.
No, I know that.
Then
actually, I put the blame on myself. I will not put any.
Like, he is a very respected senior counsel. He should not put the blame on himself.
No, I put the. My junior, it was done. He told me that.
No, it was my mistake also. I should took the blame on me because it was affirmed in the month of May. We should have served it.
That's a big step, and I said,
Senate Counsel appearing for the respondent number 6 has filed affidavit in opposition after serving the copy to the London Counsel for the petitioner. Counsel for the petitioner prays for time to file affidavit in reply. Let affidavit in reply be filed by within 1 week. The affidavit in reply filed by the petitioner in connection with the affidavit in opposition of the respondent number 125 be kept in the record. The petitioner also filed supplementary affidavit after serving the copy to the London Counsel for the respondents. Let the same be kept in the record. Please the matter. That is the problem. Once you miss the 2 p.m., then you will.
Stay here.
No, that's but short you will not. Then you will get in the August only. And that is August last week. 26th August only you will get fixed matter. Not before that. I think 3 o'clock. 3 o'clock my original side. Oh, original. 26th August at 2 p.m.
Good.
Take the book.
Come
on the next date. Yes, call the list.
Oh, well, I believe
possibly 26th may be declared as a holiday. Some dates in our calendar is to be notified later.
Oh, yes,
So 26th maybe Miladun Nabi may be there. So
27. 27.
27. Grateful.
Yes, next.
19.
I'm for the petition. Account has freezed.
Huh?
My account has been got freezed.
Yes.
Lord, I have made a transaction in the year 2024.
You made transaction 2024.
2024.
Yes.
Thereafter, my lord, I transferred my money from one account to my another account.
Correct.
Both my accounts are fixed, my lord.
Mm.
Thereafter, my lord, in the month of August, the de facto complainant was from has filed the petition before judicial magistrate to hand over her the interim custody of the money which was lying in my account. The magistrate has ordered for the same. Kindly come to page number 20.
De facto complainant means
whose money has been, my lord, defrauded. Who has made an allegation that
his money has been defrauded.
My lord,
that money has been paid by you.
It was taken from my account.
You are taken from your account by the order of the court.
Yes. Thereafter, my lord, even after that, the fees did not meet. My funds which are lying in my, my lord, account.
Where is the order?
Order, my lord, page number 20.
And I'm appearing for the bank.
Yes?
My lord, she's on her way, my lord. I'm led by Miss Panarai Chaudhary. I'm led by Miss Panarai Chaudhary. She's on her way, my lord.
Yes.
My lord,
Why you not give allowing
my lord, we have received intimation from the CID requiring, my lord, to block this account. My lord, the order, my lord, to freeze this account rather. My lord, the order that they are showing, my lord, in that order, there is no mention of PNB, my lord. And the order does not even speak about opening of the account. It is all, my lord, how the amount could be refunded back to the person who has suffered the cyber injury. If your lordship kindly comes.
made a police authority as a party, yeah?
Lord.
Which police?
My lord, Maharashtra police.
Lord, who has
Manikpur station.
Yes, my lord. Have made a
Continuous.
some effort service. Lord, maybe Lord, I am not the Lord accused. I am Lord a purchaser, Lord in the fourth or third layer, Lord. I have no connection. The person who has defrauded her has sent money to me. I have no connection. Even Lord in the Lord kindly see. They have taken the amount, Lord, disputed amount is gone from my account. If somebody is the victim, that is me. Bank, I have not contacted the bank authority. Bank authority said, Lord, kindly have patience. And again.
What is your bank account number?
Lord, my bank account number, Lord, is Lord, in the paragraph 5.
Lord, kindly sees.
Axis Bank account.
Axis Bank. Lord, kindly sees this.
5 of the page number 21. The order will not mention.
That's why. What is your account number?
920-0100-11625-304.
My lord, may I indicate one thing? If your lordship, my lord, kindly comes to page number 20, in paragraph number 2, your lordship will find that account of ICICI Bank has been mentioned and account of, my lord, this Axis Bank has been mentioned. Nowhere, my lord, the Punjab National Bank's account has been mentioned. My lord, we were not aware. We have just received an intimation from the CID that block it. My lord, once that goes, my lord, I have.
Your account is which bank?
Lord, I have 2 accounts. Lord, I initially received the money in the PNB. On the same night, Lord, I have transferred the money to my Axis Bank account. Both the bank accounts, Lord, has been freezed. Lord, kindly, Lord, come to my.
And which account the 52,000 was refunded?
Axis Bank.
Axis Bank.
Axis Bank.
Lord, I have annexed the page. Lord, kindly come to Lord page Lord 41. 41, Lord, is they have taken our money. Lord, kindly see from the top 8 lines, 28th of August 2020. Money was not transferred in the account of Pallavi Dattatreya Rane.
Where is that?
Lord, from the top, Lord, 8 lines.
52,000.
52,000. It was not taken out. Even after that, Lord, the fees did not leave. Both my accounts till date are, Lord, under fees.
So you are appearing for the PNB.
I'm appearing for the PNB.
What about the Axis Bank?
Yes.
Axis Bank was freezed.
No, the amount was this amount was deducted from the PNB or pack?
No, Axis Bank.
And what is the amount in your account?
18,000.
And what is the amount in the account Axis Bank?
Maybe 5 to 6,000.
5 to 6 lakhs.
Say 1,000.
Where is the affidavit?
All Lord, sir. Axis zonal Lord have refused.
Who would refuse?
Lord, respond number Lord maybe. Respond number Lord.
Where is the Axis Bank account?
Lord, the prayer portion.
Account. You are not disclosing the statement of account of the Axis Bank.
Yes.
Where is that?
Lord, page number Lord.
Well, it starts from page number 26 onwards.
Punjab
It's
National
Narendra
Bank.
Nagar branch, Belghoria.
Now, Punjab National Bank is at page number 28. Page
number Lord
25.
26.
26. So what is the amount? 16,000.
17,000 and.
Where is that?
My lord, if my lord kindly comes to page number 25, my lord. My lord will see amount 17,344.91. This is the amount line.
June 25. As on June 25.
As
right?
on
And in the Axis Bank,
Lordship will see.
what is the latest amount?
Page number 20.
Huh?
4,000. My instruction says.
As on date, what is the amount?
No, as on date statements, they have probably not given, my lord. It is up to 2024.
Correct. When the account was seized?
In the middle of 24.
24, which date? Both account.
All account.
So what can be done?
Well, let the police appear once. If
They're not appearing. Affidavit is there. Affidavit service is there.
well, at once,
You do one thing.
whether they require these accounts for the transaction.
Correct. I am fixing you. You submit your report. What is the amount total?
Lordship,
And
please.
you communicate the Axis Bank also.
Lordship.
And again you serve the notice to the police. I am fixing after 10 days. If they will appear or you file the report, then I will pass it.
Lordship.
The petitioner has filed the affidavit of service. Let the same be kept with the record. In spite of the service, none appears on behalf of the respondent except the non-advocate appearing for except on behalf of the Punjab National Bank.
Lordship.
Full stop. This court finds that the report is required to be filed by the bank to ascertain how much amount is pending in the account of the accounts of the petitioner lying in the Punjab National Bank as well as Axis Bank.
Lordship.
And the police has to file the report whether the freezer of the account is further necessary for the investigation of the case, if any, pending in connection with the said account of the petitioner. In view of the above, the bank authorities are directed to file report within a period of 1 week from date. The police authority also directed to file the report whether the account of the petition is further required for the investigation. Police stop. This is the matter on 10th of July 2026. It is made clear that if no report is filed, appropriate order will be.
Lordship, since the police is of Maharashtra, will the central...
That is center note. They will not come.
Great.
Next.
I'm told Mr. Amitabh Ghosh is leading his matter here. Mr. Amitabh Ghosh is leading his matter. Can you give us whatever he is?
What is the matter?
My lord, illegal.
What is the prayer?
Illegal detention for 16 months, my lord.
Huh?
Illegal detention since 16 months, my lord.
Repatriation of the petition, compliance of the judgment and sentence. Who is a Rohingya? Is a Rohingya?
Yes, my lord.
Bangladeshi. Who is for the state?
We not serve my. There is the matter, my lord. Serve the copy to me in next location, my lord.
Where is the conviction order? Where is the order of conviction?
My lord,
No order of
my lord.
conviction, huh? You are not disclosed. You disclose the FIR. What the FIR will do? Now he has been convicted and
My lord,
sentenced has
27 February 2025, my
Where is
lord.
the conviction order? Nothing.
Mr. Meet, my lord. My lord, page 14, my lord.
Page?
14, order dated 27 February 2025.
What is the name? Client name?
Mohammed Ikram.
Muhammad Ikram. Page number?
14, 1414. Well, this is my previous affidavit of service, my lord.
Accused Muhammad Ikram is found guilty of the offence punishable 14A(b) and sentenced to suffer simple imprisonment of 6 months and to pay 1,000. Undergo further so and so so and so. When he was arrested, how many days he was in custody? When he was arrested and since when he was in custody?
My lord, he was arrested on 4/8/2024, my lord.
4/8/2024. Yes.
My lord, his suffering was conviction from 4/2/2024.
Conviction was on 27th February.
Yes. My lord,
27th.
6 months and 1,000 in default 2 months. So it was completed on 4/4/2025. And thereafter,
Already
my
set
lord,
off.
14 months I am in unauthorized detention.
So when the order of conviction was passed on
Conviction is 14. Conviction was
when the conviction order was passed on that day, you already
yes.
undergone the sentence.
Yes,
More
468.
than that.
More
So
than that.
468 has given the benefit
Yes.
to you. Still you are in custody.
Yes, 14 months I am unauthorized
Yes.
detention. 60 was 60.
Where is your home stay?
No copies are malad.
Foreign nations you give.
Same issue of connection malad 4 matter fixed in
Ah.
court malad. Local Chatterjee malad.
Correct. That's why I you instructed to take instruction from the state authority whether any home has been identified to keep the foreign nationals in that said home. Why did these persons have been kept in the correctional home? And if I will release this person on bail, where they will go? And who will give the security of this person? Under 14.
I have to take instruction malad for this matter.
How soon? When the other matter is fixed?
July malad most probably.
July is when? Which date? I am fixing this also. Which date?
এই আরেকটা মামলা আছে না এরকম? এখানে আরেকটা মামলা আছে না?
The petitioner has filed the present application for release of the petitioner from the correctional home as the conviction, the sentence imposed upon the petitioner has already been completed. Learned counsel for the state pressed for time to take instruction whether the state authorities have made any arrangement for keeping the foreign nationals if they have been released from the correctional home. Let the instruction be full. Let the matter appear on. No. You have no knowledge which date. Let the matter appear on 9th July for instruction, for taking instruction by the state authority. Affidavit kept with the record. Yes. Close.
May I have my lord?
My lord, let the information have been kept in record. Grateful, my lord. Please read out.
Which one? Appellate side?
Yes.
Ah.
My lord, it's expiring today, my lord. This is the last order. To change the 149 months.
Record on. Who is for the respondent? Though the matter is listed as item number 149 of the monthly list, but due to paucity of the combined monthly list. Acha to? But due to paucity of time, the matter could not be taken up for hearing. Full stop. Then counsel for the petitioner mentioned the matter and praised and submitted the interim order still today and paid for extension of interim order. In view of the submission made by the counsel for the petition, interim order is extended till 30th July 2026 or until further order whichever is earlier. Let the matter remain in the list.
Your lordship. Madam, I am appealing on behalf of the National Highways Authority.
What is the interim order?
But till today, March.
What is the interim order?
There was an order passed evicting us and cancellation of a LOA. My affidavits are ready. But
my lord can be very shorted, my lord, since my learned friend enjoying my lord this case.
Affidavit filed.
My lord.
May I file my reply, my lord?
But I also received the copy, my lord.
Keep you on the next record. Though the matter is listed as item number
23, my lord.
23 is the rest list, but due to paucity of time, the matter could not be taken up for hearing. Then counsel for the petition submitted the interim order still today and wait for extension of interim order. Learned counsel for the respondent raised objection and submit that due to the interim order, the authorities are facing difficulties for completion of the project. In view of the submission made by the counsel for the parties, let the matter appear on. Let the matter appear on 16th July 2026 under the same heading within 20 matters. interim order is extended. कब बोला? 20. Date कब बोला? Let interim order is extended till 17 July 2026 or until further order.
My lord, I'm for item number 55 and the interim order is expiring today as per the last order. We are praying for the extension of the interim order in the
Which
matter.
was the other side?
We have mentioned by way of mentioning notice to
Item
the
number
respondent.
55?
Yes, yes, your lordship.
55 bit. Though the matter is listed as item number 50. Till 31st July or until further order, whichever is remaining.
Side order.
Yes. Close.
23.
Upon notice, my lord.
Lord, I
This is Lordship's order of 30th April. Fixed on 8th. Yes. Well, no, it's fixed on 7th July. 7th July, my lord, I am in some personal difficulty. That's why.
8 is not 3 PM is vacant, no. 8 July नहीं होगा ना? खाली नहीं है ना?
Any other day convenient to your lordship. Any other day.
My lord, kindly fix a short date, my lord, because bank is suffering interim order since long.
What interim order?
No, because that shows not to file an appeal and accept the interim order. So you are liable to suffer. Any day convenient to your lordship. Any available dates.
29 July.
Very well. 29 July.
Learned counsel. It is not in the list, na?
No, it's
Learned counsel for the petition mention the matter and submit that by an order dated 30th April 2026. This court has fixed the matter on 7th of July 2026 at 3 PM. But on 7th July 2026, he is having some personal difficulties and not in position to appear before this court and paid for fixing the matter to some other date. Then counsel for the respondent raise objection and submit that due to the interim order obtained by the petitioner, Common Bank is facing difficulties and she is praying for fixing a short date. In view of the submission made by the counsel for the parties, let the matter appear on 29 July at 3 PM.
Obliged.
Interim order is continued, absolute.
Fine.
May I be permitted, Lordship?
Yes.
Item 147 of the day's list is a specially assigned application for contempt. My lord, the Lordship last order said on 8th May, the interim order is expiring 30th June, which is on date. My lord, the interim order may kindly be extended.
What is the interim order?
Interim order originally passed was on July 25, 2025. When the contempt application was moved for the first time, that the we had said that the property has been sold by the contempt number 1 to the contempt number 2. Interim order was there. They will not further deal with or
Himachal Pradesh or
no, this was in Meghalaya.
Meghalaya.
So as Lordship interim order was there, they will not deal with further dispose of income. Now, my friend is appearing for the buyer.
I am appearing with the content number 2, my lord. My lord, if your lordship looks at this order once at paragraph number 13.
What's the date of the order?
Date, 2nd April. There is a rider, my lord, if the petitioner takes steps in issuance of warrant, the department is directed to issue warrant upon my lord, the content number 2. My lord, as on date, my lord, upon issuing, my lord, serving the notice that was served upon me, my lord, I have appeared, duly appeared. That being, my lord, dispensed, my lord. This is my humble.
He has not filed any affidavit. He has
You appeared.
My lord, I have appeared on the last occasion when the interim order was extended. Thereafter, your lordship was of the view that when the matter will be taken up, appropriate orders can be passed.
Correct.
So, my lord, whether or not the warrant has been issued or not, that let the petitioner come out, your lordship.
Yes. So there is no warrant. Have you taken steps?
No, after this, Mother, he is appearing. Now he has to file an affidavit. He is out of time, long time.
What?
No.
What?
That no steps regarding issuance of
No, why?
by the petitioner in that.
He is supposed to answer the contempt. He is not filed his affidavit.
Number?
147 of
So the
days
matter is
list.
listed as item number 147 on the today's list. but the Land Council for the petition has mentioned the matter and submitted the interim order till today. Land Council for the alleged content number 2 submits that by an order dated 2nd April 2026, this court directed that if the petitioner take steps for issuance of warrant, the department is directed to issue warrant of arrest upon the alleged content number 2. He submits that though the order was passed for issuance of the warrant of arrest against the content number 2, but the petitioner has not taken any step, and the alleged content number 2 already appeared before this court voluntarily. In view of the above, full stop. Let the full stop. In view of the above, this court find that as the content number 2 is appearing voluntarily before this court, thus issuance of warrant does not arise. Full stop. The interim order is extended till 31st of July 2026 or until further order whichever is earlier, let the matter remain.
Lordship, only one thing, he has not filed any affidavit to answer. So then he will face the consequences. Other contaminants of there was a direction. He has chosen not to file. He will face the consequences whenever the matter is taken up.
Yes,
my lord, may I have lordship
Then again,
mention the matter, my lord. Item number 164 of the lordship's list, my lord. My lordship initially fixed the matter before my lord vacation, my lord, but my lordship was not there because of
160?
64, my lord.
What is the matter?
I am the intervener, my lord. It's a partition suit, my lord. This confirmation of sale, my lord. My client is the highest bidder and put in the money, my lord. Since 2013, my lord. My client is, my lord, at the age of 80, my lord. Your lordship already fixed the matter before vacation, my lord, but your lordship was there in the circuit bench. That is why it could not be taken up, my lord. Your lordship kindly please.
164?
Yes, my lord.
It cannot be disposed of.
Yes, my lord. My application.
Yes.
I am not the party to the suit, my lord.
Because more than the parties, there are more interrogatory application.
My lord,
choose the court where the court is not
my
having any
application,
work, then you go
my
with all
application,
this.
my application is GA number 185 of 2018, my lord.
Then other party will come, my application, then other party will come, other
lordship,
application for settling the GA the whole day from 10:30 to 4:30 will be over.
No, my lord, take it up because my client is 80. My client is 80.
To choose if you want you want to not press all the GA, I will take the main matter. That's all. I am not interested with any interrogatory. If you are interested with the main matter, you come with all the parties. I will hear the matter in one day.
It's not possible for me because I am not party to the suit. It's a specially assigned matter. I kindly appreciate
50 GA. It is not possible for
it's a specially assigned matter. My client is only one GA, my lord.
I beg to appear of the petition.
Yes. Who is appearing for the bank? Who is appearing for the bank?
Who is appearing for the bank, lordship?
Both.
Both, lordship.
Punjab and Sindh and Indian Bank. Indian Bank.
Both, lordship. I am appearing for the both, lordship.
So, the affidavit of service may be kept on record.
Lordship, before the senior counsel starts, I am to make one submission, lordship. I need to produce a letter of appointment of this to the petitioner. Now, lordship, since the appointment was made long time back, the bank couldn't find it, and lordship, we need some time to find an appointment letter
of
the office appointment as an impanel.
Appointment
your appointment.
Yes.
Yes. No. Appointment of the petitioner.
But the petitioner.
That appointment letter is required, lordship. Bank is still searching for it.
He was impaneled with the bank. Now, my lord, he was entrusted to cause search in respect of a property for which, my lord, the borrower had approached the bank to obtain loan. Now, my lord, he submitted his title search report, which is at page 37.
Yes.
Lord, kindly see page 37 under the heading description of the documents verified scrutinized. Your lordships will find the deed of conveyance. Then, Lord, there is a deed of gift. These are all, Lord, registered documents. Deed of gift, then mutation certificate, tax receipt, sanction plan issued by South Domdom Municipality. Then, Lord, measurement, location, all this is there. Such report, Lord, is at page 38. I have further searched the record of the office of ADSR, Bidhannagar DSR 2, Barashat and ARA, Kolkata. As far as available records, no adverse entry was reported in the name of Promit Maiti. He is the borrower.
in respect of Bastu land measuring 3 kata 8 chata 26 square feet together with 4-storied building lying and situated at such and such within the limit of South Damnam. Then note the flow of title, and this is there up to page 40. At page 47, your lordships will find the signature and note the date, 16th of November 2018. Now, Lord, this was his report. Now, Lord, based on this, Lord, certainly at page 104, if your lordship comes to, and Lord, the supporting documents are there. I am not troubling your lordships. The certificate of death, the mutation certificate, Lord, this is just to show that he had done, Lord, the due diligence in respect of the property. Page 104, if your lordships, my lord, kindly come to, my lord will find, suddenly he receives this letter from the bank. It is in 2022. The report was in 2018. Kindly, my lord, take the last paragraph, but it has come to our notice. Has your lordship found that?
Yes, yes.
That the title deed is not genuine and the borrower have committed cheating and deception with aid of forged and fabricated land documents. In this regard, you are requested to submit your comment within 7 days of receipt of this letter. Now, my lord, he gives a reply which is at page 105. He says that I have gone by public records. Lord, there was no proceedings pending seeking cancellation of the document. So, my lord, he says that I have gone by the public records. And your lordships will find from the letter of 104, it is also not their case that due diligence was not performed in respect of any proceedings which was pending in court. Now, my lord, your lordships will find at page 105, kindly see the last paragraph, your lordships will understand. The aforesaid such report was made on the basis of certified copy of the deed of gift, quote such report, and other copy of the documents as relied in my aforesaid such report. The copy of the deed of gift that is such and such registered with the Office of Additional District Sub-Registrar Bidharnagar such and such for the year 2013 is annexed here too. So, my lord, he says that I have gone by public records. Whatever records I searched, I found. I have gone by those records. I have searched the court records. There was no proceedings pending. So, this is what my report was. Now, my lord, what happens? There is no reply to this letter. They don't give any show cause. But what I find, certainly, my lord, at page 107, your lordships will find, this is, my lord, the website of Punjab and Sindh Bank. It says actions against professionals depaneled from the bank. Has your lordship found that?
Yes.
And the name of this gentleman is at page 112. Item number 50.
Yes.
Now, my lord, on seeing this website, he writes a letter to the bank at page 113 saying that please let me know whether you have also disclosed my name in the caution list of Indian Bank Association, because my lord, he works for many banks, not just these two banks, but many banks. So therefore, he said that please please let me know whether you have issued. Kindly come to page 113, paragraph Lord 16, which is at page. Sorry, this is Lord paragraph. Kindly come to paragraph 14. Sorry, page 117. In the circumstances narrated above, you are requested to forthwith intimate if the name of the firm undersigned has been included in the caution list of IBA, and in the event the same has been included in the caution list, inform the firm undersigned as to the procedure which was followed with respect thereto. Now, my lord, there is no reply to this letter. Now, my lord, your lordships may kindly come to paragraph 16. They come to know, the gentleman comes to know that, Lord, his name was forwarded and included in the caution list. Paragraph 16 of the writ petition. that upon further inquiry, page 7.
Yes.
That upon further inquiry, the petitioners came to know that the respondent number 1 had not only included the petitioners in the list of depanel professionals, but had also forwarded the petitioner's name to the respondent number 2 for inclusion in the caution list maintained by the respondent number 2 and circulated to various bank and financial institutions. Also, the respondent number 2 most arbitrarily, illegally and contravention of RBI guidelines, principles of natural justice, included the name of the petitioner under the caution list and forwarded the same to the other bankers with whom the petition number 1 is empaneled. Then, Lord, please come to paragraph 18. The petitioner said the inclusion of the name on the depanel list of the respondent number 1 and the caution list of the respondent 2 has adversely impacted the petitioner's professional reputation and credibility, thereby resulting in loss of present and prospective professional opportunities and potentialities, affecting the livelihood of the petitioner. And then, Lord, paragraph 20, it is said that it is an effect is of blacklisting. So, Lord, if they wanted to blacklist, they had to, Lord, give me a show cause notice. They had to, Lord, give me a hearing and then pass a reasoned order. And Lord, there is a guideline which is at page 19. If your Lordships, Lord, kindly come to page 19.
Yes.
This is Indian Banks Association guideline, which is there. Kindly take the first paragraph.
Yes.
Kindly see the second sentence. It starts with the word before reporting to IBI. The banks are required to satisfy themselves about the involvement of third parties concerned and also provide them with an opportunity of being heard. Banks have been advised to follow formal procedure and suitably record the process followed. Though banks have been advised to report such incidents to the respective self-regulatory organization of this professional, banking system as a whole needs to be cautioned about these third parties. Hence, RBI has requested IBA to prepare caution list of such third parties for circulation amongst banks. Then, Lord, kindly see page 24. Kindly see page 24, clause 2.
Yes.
Definition of third-party entities, TPE. Kindly see the last 4 lines, starting with the word the transaction could be related
to any service.
To any service bank provides to this customer. Example, TPE could be builders, warehouse, cold storage owners, tractors, etc. Lawyers, chartered accountants, and property valuers. Kindly come to page 27. Which talks about process of evaluation. Kindly come to B first, 6B. If during investigation of a fraud, it emerges that third parties are involved, the investigatory report should contain the details of the third parties and extent of involvement in the fraud. Then C, the investigation report would get forwarded in the normal course to the group reporting frauds to RBI for reporting the same in the frauds reporting monitoring system. Then, Lord, please take F. The forum will be guided by the principles of natural justice and act independently and impartially. Now, kindly, Lord, come to the I. The TPE will be asked to reply to the letter within 15 days of receipt of the letter. Then J. The TPE replies with an explanation for his or her action. A meeting of the forum will be convened and the reply discussed. And 31, your Lordships will find the right of hearing is provided. Kindly, Lord, come to 31, the last bullet point, the second last bullet point. Before sharing the data, has your Lordship found that?
Yes.
However, RBI has highlighted that banks need to satisfy themselves of the involvement of third parties concerned and provide them with an opportunity of being heard. The bank needs to follow documented process for the same and the matter should be suitably recorded. There is nothing, Lord, here. There is no show cause. One, that letter says you give a reply, that reply is given, and then, Lord, I come to know that I am not only depanel, but, Lord, they have also, Lord, sent it to the banks, Indian Banks Association, for the purpose of, Lord, for the purpose of including my name in the caution list. Now, my lord, kindly see the prayers now, what I am asking for. I'm really, my lord, asking for prayers B and C, or D, whichever, B or D, B and D. Now, Lord, just Lord, I find that these issues have come up, Lord, before the court. Lord, what is to be treated as fraud? Lord, I make a sincere attempt for the purpose of finding out about the encumbrance, etc. I go to the public records. There is no other way of finding. I see the court records, I see the public records, the registration officer, and I give a report that these are registered documents, and these documents, based on these documents, the mutation has taken place, construction has taken place, sanction plan is there, and that is how, Lord, I give a report. The question is that today this effect is of a blacklisting. How does one react to this? Now, Lord, there is a Bombay High Court judgment exactly on the same line, 2023, that 2022 SCC online, Bombay 1628. Lord, please come to paragraph 9. Paragraph 9. After hearing both sides at length, the short question that arises for consideration is when an advocate acting professionally and in discharge of his or professional duty renders an opinion by giving non-encumbrance certificate to the bank for granting loan to a borrower, certifying that he has clear marketable title which is subsequently found unacceptable, could the advocate be held liable for any action? Admittedly, the petitioner was on the panel of the bank. There is no dispute that the petitioner is a practicing advocate since last 30 years. It is not denied by the bank that the petitioner had represented several institutions such as Dr. So-and-so, so-and-so. It is an admitted fact that in the year other educational institutions, it is admitted that year 2012, the petitioner was requested by the Bank of Baroda, branch of Jalna, so-and-so, issuing his title opinion report in respect of the property belonging to Mrs. So-and-so, so-and-so. Then, Lord, please come to, your lordships will find that he had submitted the title report. Paragraph 10, if your lordship then comes to, we have perused the search report issued by the petitioner. From the said search report, it appears that the petitioner had taken the search in respect of various aspects like whether money, minor, etc. He also ascertained whether the property is freehold or leasehold and accordingly answered the affirmative. He further ascertained that the said property is the acquired property of such and such. Such report further revealed that mortgager is in exclusive possession of the property, etc. Then, Lord, paragraph 11. Nowadays, it is a settled practice that for obtaining loan or while granting loan, rendering a legal opinion has become an integral component of an advocate's work in banking sector. Therefore, an advocate on his part has responsibility to act to the best of his knowledge and skill and to exhibit an unremitting loyalty in the interest of his client. An advocate is required to exercise due diligence in a manner that would advance the interest of his client. However, while acting so, the advocate never assured his client that the opinion so rendered by him is after taking due precaution and care. Like any other profession, the only assurance which an advocate can give and may be implied from an advocate while acting in professional capacity is that he possesses the requisite skill in his field of practice, and while undertaking the performance of the work entrusted to him, he would exercise his skill with reasonable competence. In this regard, we may refer to the following observations made by the Honorable Supreme Court in the case of Central Bureau of Investigation versus such and such. reported in such and such, where a first information report came to be lodged for commission of offences punishable under the section such and such, read with 13(1)(d) of the Prevention of Corruption Act against various accused, including a legal practitioner, who was a panel advocate of the bank. It was alleged that the said panel advocate had given a false legal opinion with regard to 10 housing loans. The legal practitioner filed proceedings under section 482 of the criminal procedure for quashing of the criminal proceedings. The Andhra Pradesh High Court quashed the said proceedings against the legal practitioner. That order was challenged before the Honorable Supreme Court. In paragraph 27 of the said decision, it has been observed as under. In the banking sector in particular, rendering of legal opinion for grant of loans has become an important component of an advocate's work. In the law of negligence, professionals such as lawyers, doctors, architects, and others are included in the category of persons professing some special skill. A lawyer does not tell his client that he shall win the case in all circumstances. Likewise, a physician would not assure the patient of full recovery in every case. A surgeon cannot and does not guarantee that the result of surgery would invariably be beneficial, much less to extent of 100% for the person operated on. The only assurance which such a professional can give or can be given by implication is that he is possessed of the requisite skill in that branch of the profession which he is practicing, and while undertaking the performance of the task entrusted to him, he would be exercising his skill with reasonable competence. This is what the person approaching the professional can expect. Judged by the standard of or by a professional may be held liable for negligence on one of the two findings. Either he was not possessed of the requisite skill which he professed to have possessed, or he did not exercise with reasonable competence in given case the skill which he did possess. Then Lord, kindly come to paragraph 12. Admittedly, in the present case, the work of submitting a title report such was entrusted to the petitioner. Accordingly, the petitioner had carried out the inspection by visiting the sub-registrar office, inspected various documents in sub-registrar's office as well as the documents supplied to him by the bank. On the basis of the said documents, he had prepared his search report, title report submitted to the bank. At the same time, he had also taken care to recommend some safeguards to be followed by the bank. His search report shows that he had suggested the bank it should obtain an affidavit, etc. Then, Lord, please come to the middle of the paragraph. In the present case, has your Lordship found that? Before the empanelment of the petitioner, the bank ought to have given him an opportunity to the petitioner to justify his search report. Admittedly, bank has not given any opportunity to him and has issued the communication on December 16, 2019. Said communication was replied by the petitioner by giving his justification as to the basis on which he came to the conclusion that the property had clear marketable title. Perusal of the petitioner's reply dated so and so reveals that after receiving the communication dated December 16, the petitioner again carried out inspection. Even on that day, the said register did not reveal any transaction or sale as alleged. Copy of the certified copy of the property card obtained, etc. Then Lord, kindly see from the aforesaid, it becomes clear that the communication dated such and such stating that the petitioner had submitted a wrong title search report does not disclose the correct state of affairs. While the petitioner has relied upon Index 2 register of the property obtained so and so to support his opinion that the property had a clear marketable title, the bank has found that 7 shop blocks had been sold out in 2001 as per title search report obtained by it. In this regard, so and so, the bank did not obtain such affidavit from any director of the company. Then Lord, kindly come to coming to the challenge to the show cause. Lord, here there was a show cause. In our case, there is not even a show cause.
Next page, para 13.
Para 13. Yes. It is to be noted that the scope of interference in the stage of issuance show cause is limited. If the show cause notice is issued with premeditation, authority issuing the same, then Lord, it says that even a show cause notice can be interfered by the court. That is Siemens. That and paragraph 14. Then Lord, 15 is the conclusive. The petition is allowed. Following observations, the communication issued, which are upon detailed investigation, it was noticed that you did not submit your so and so. Or these are Lord, cancelled. Yes. The show cause notice issued by the bank is Baroda. It is quashed with liberty to bank take appropriate step if so advised. Now, my Lord, here there is no show cause notice. Excepting for that one letter,
They want opinion.
they wanted
Our comments.
comments. That is, Lord, seeking comments at page 104. That's the only letter, only communication. And when the reply went, there is no, my lord, reaction. Now, my lord, there is one other judgment on which, my lord, I want to rely on. That is, my lord, on the question of debarment. That is, my lord, 2024-15 SCC, page 264. Lord, kindly straightaway come to paragraph 21 onwards.
Yes.
The heading is reasons and conclusions. Has your lordship got that? Blacklisting has always been viewed by this court as a drastic remedy, and the orders passed have been subjected to rigorous scrutiny. Eurasian equipments is quoted. Then, Lord, the B.N. Joshi, kindly, Lord, come to paragraph 24. The judgments, Lord, I am skipping. What is significant is that while setting out the guidelines prescribed in the USA, the court noticed that comprehensive guidelines for debarment were issued there for protecting public interest from those contractors and recipients who are non-responsible, lack business integrity, or engage in dishonesty or illegal conduct, etc. The illustrative cases set out also demonstrate that debarment as a remedy is to be invoked in cases where there is harm or potential harm for public interest, particularly in cases where the person's conduct such demonstrated had that debarment as a penalty alone will protect public interest and deter the person from repeating his actions, which have a tendency to put public interest in jeopardy. In fact, it is common knowledge that in notice inviting tenders, any person blacklisted is rendered ineligible. Hence, the blacklisting will not only debar the person concerned from dealing with the employer concerned, but because of the disqualification, their dealings with other entities also is prescribed. Even in the terms and conditions of tender in the present case, one of the conditions of eligibility is that agency should not be blacklisted from anywhere. In other words, where the case is of an ordinary breach of contract and the explanation offered by the person concerned raises a bona fide dispute, blacklisting debarment is a penalty, ought not to be resorted to. Debarring a person, albeit for a certain number of years, tantamounts to civil death, inasmuch as the said person is commercially ostracized, resulting in serious consequences for the person and those who are employed by him. Too readily, invoking the debarment for ordinary cases for breach of contract where there is a bona fide dispute is not permissible. Then, not examining the facts of this case from that perspective, we find that the appellant, after the award of the tender, has admittedly paid an amount of such and such. And then, Lord, it says that.
Yes, next.
Paragraph 29, your lordships will find. Now, Lord, on the question of public interest, there is not a single, Lord, instance given that apart from this case, there were other cases where, Lord, there was any lapse. Your lordships will kindly see page 104, where they had sought for comments.
Yes.
My lord will find they merely say that they have found that the title deed is not correct, not genuine. That is the only allegation. And Lord, it's not say
after the page 112, 111, this
yes, 111
D panel.
Yes,
correct. Then what? Nothing has done. Not
no D panel after nothing. Lord, then Lord, I come to know when this depaneling is done. I see the website and I come to know that the depaneling has been done. So, Lord, I write a letter saying that let me know whether you have put my name in the caution list.
Correct.
Caution list means, Lord, all the banks will have access to.
So that is not done.
That has been done. That is it. That has been done. Paragraph 16.
No, you have mentioned that.
Yes.
You have mentioned that.
The bank has not, Lord, intimated me anything. That's why in the letter that I have written at page 105, your lordships will find that I have said that you let me know what procedure have been followed by you. Because the procedure is prescribed. First, you will have to give me an opportunity of hearing. And by giving a show cause, reply, then hearing, and ultimately the order is passed. That's how the proceedings is.
Yes.
So, Lord, today.
So I can deny that has not been done. That I cannot deny.
What?
That show cause and hearing has not been provided. Not being done. That I cannot deny.
And whether the name has been sent to the IBA?
Yes, it is there. It is in page 107. Blacklisting that has been done. That's what the allegation is. They wanted to remove this.
107 is their website.
These are the panel.
This
With
is their
regard to
website.
The panel. The panel, it's okay. And you have sent the name to the IBA. Indian
So
Bank.
that the bank has not communicated to me, Lordship, because I received that they have to communicate, Lordship. And I also
How
need
the
to
bank can do all this?
and I can also need to produce the appointment letter, Lordship.
What appointment?
The appointment of the petitioner
What
as an empanelment. Because I was told that something is there that they have agreed that without giving any show cause or any hearing, they can be depaneled at any moment. That is there written in the show cause letter. But since the empanelment was done long back, the bank has not yet been able to find it.
Not in a bill to
Find it, find the appointment letter. The bank requires some more time, Lordship. At least give us 2 days. By that time,
appointment letter, it's okay. But you are depaneled amounts to
no,
depanel advocate.
depanelment is something different. They are saying whether they have been blacklisted.
Depanelment is
There
also
is
blacklisted.
three issues are there. First, there is no denial that he's not a panel advocate because he has given the opinion. On the opinion, you have given a letter to him asking the comments on that. He has submitted the comments after the
No, he has been depaneled from the bank.
Yes.
He has been depaneled from the bank.
Correct.
Now, their allegation is whether they have been blacklisted because that name has been sent. Huh?
Depanelment is blacklisted.
Depanel, what is depanel? Depanel means
depanel from the bank's panel.
Depanel is sent to the IBA. It will be the whole bank.
That's the question, Lordship, whether that has been sent to the IBA or not, Lordship. I have asked the bank, but they have not yet provided me with that instruction. That, Lordship, I need at least 2 more days, Lordship. I'll come back with that instructions.
Come with the proper instruction.
I'll come back.
And ask, I will, otherwise you will be in difficulty. There is no so cause how your depanel will.
No, that is there. I'll come back with that instruction.
And he has given the reply. He has neither after the reply he has not done anything.
No, I think no reply has been given to their.
And what is the fraud? What is the fraud committed by the advocate?
No, so fraud has.
What fraud?
Mentioned in page 104.
What fraud?
The title deed that with the title of the borrower, this person, Promit Maiti, his title was not genuine. That's the allegation we have made.
Certified that the Promit Maiti is valid, clear, and absolute and market title.
He is the borrower. He do not have the valid title of the property that has been mortgaged. That's the allegation we have made.
But can you see?
I will produce that document, Lordship.
Can you see this opinion search report, page 37? What are the document he has consulted? He has mentioned all these things.
Documents are also annexed.
What are the document he has consulted for giving that search report? He has mentioned
that is correct. That is there. But Lordship, kindly give me 2 more days. I'll come up with that instruction.
Suppose that deed is forged one, but before, when he was taken into consideration, that deed was a certified copy of the deed, registered this. How he came to know that is a forged deed?
That's why I'll come up with an instruction.
Because you are the bank advocate. Okay, if you go to the authority for searching out whether I am the recorded owner of the property, if my name is recorded,
that's correct. Whatever the search reports are there, I have to rely on that.
Then, when you will come with the total report?
Lordship, on Monday, Lordship.
Come with the report. What report you bring?
Lordship?
What report you will bring?
Lordship, I have told that some FIR has been made. Some police complaint has been made against the borrower.
Correct.
I think those documents are there. I've asked the bank, they will provide it to me. I'll produce it all, whatever is there.
Just one letter, 105. If your Lordship kindly sees the first, second paragraph. Look, these are the documents which were forwarded by the bank to conduct a search. And based on that, Lord, he went to the ADSR and other Lord, public authorities for the purpose of searching it out. So, Lord, whatever documents were forwarded by the bank, based on that, the search was conducted and they registered that gift deed is the only, Lord, document on which they are harping. That is a registered document coming out of the public record. And Lord, it is not their case that any suit is filed by anybody asking for not cancellation of the document or anything which was not looked into at the stage of inquiry.
The
Lord, kindly, Lord, protect him, Lord, so far as interim protection is concerned, kindly, Lord.
What protection?
Lord,
Because
kindly,
that,
Lord,
the
say this-
panelment is a 2025.
Yes, the panelment is 2025, but Lord, because of this correspondence, etc., Lord,
I am
panelment is
giving you, you
2020.
come on Friday. I am fixing on Friday. Let it come with the report.
Friday,
Doesn't
fine.
matter. This court find that a report is required to be filed by the bank to ascertain whether any so-called notice has been issued to the petitioner or whether the before the depanelment of the petitioner from the bank, the panel of the petitioner, and whether the bank has forwarded the name of the petitioner to IBA for recording
Caution.
for caution IBA. Okay? Let the report be filed by 2nd July 2026 after serving the copy to the land council for the petitioner. Leads the matter on 3rd
July. Friday is
matter on 3rd July.
3rd July.
3rd July at the top. Same ending under the same.
Much.
Yes.
Your Lordship, on behalf of the respondent,
Hmm.
I am withdrawing my wakalatnama for this case. So, and I have this. This is the intimation supplements.
Why?
Personal reasons. And she will be appearing, and
who is appearing?
She will be. She has not filed till now. So.
Lordship, I am appearing for the Union of India. I apologize. There's some problem with my camera, Your Lordship. I am appearing for the Union of India.
I'm led by Ms. Gupta. I'm appearing with Ms. Gupta.
Union of India.
Yes, Your Lordship.
Yes. Yes, madam.
Lordship, I will submit my VOCA next day because I didn't receive any authorization from the organization. So I need a few days more.
And the last occasion, this honorable court has asked 3 queries regarding some points on the part of if this honorable court allow me to submit those points. So first, some of the queries which has been raised by this honorable court.
Lord, I take it that he is still appearing as a counsel.
No, because still as she has not filed.
But he has withdrawn. Let him continue then. Apparently, he has withdrawn the wakalatnama, so he's still appearing as a arguing counsel. I'm taking it.
How soon you will be ready?
Lordship, it will take few days from there.
2 days means how? So that's why I'm asking, so that I can fix a date.
Yes,
to your argument.
Because
is
my submissions are over.
submission is over.
Completely
Your
done.
reply is going on.
And my lord, this is a question of because the patent is.
Lordship, as far as the union is concerned, Your Lordship, we would request for a date in the first week of August.
What the Union of India will do?
Union of India hasn't even filed any pleadings, my lord.
Yes, we haven't, Your Lordship, but we have short submissions to make.
London advocate appearing for the respond number 2 and 3. 2 and 3. 2.
I am for respondent number 1, Union, Your Lordship.
Respond number non-counsel appearing for the respond number 1 has withdrawn his power.
No. Respondent
number 1.
2.
1. Yes, sir.
Respond number 1.
I'm sorry.
I'm respond number 1.
Non-counsel appearing for the respond number 1 has withdrawn his power.
I'm sorry, Your Lordship.
Power. Full stop. So and so appearing for the respondent number 1 and prays for time to get ready in the matter to argue the matter. So and so appearing for the Union of India. Prays for fixing the matter to some other date to argue on behalf of the Union of India. Heard the learned counsel for the respective parties. Let the matter appear on
Praying for first week of August, Your Lordship.
3rd August, 3 p.m.
Lord, only one.
Very well, Your Lordship. Obliged.
The respondent number one had already started its submissions. I now obviously change an advocate, that's a different thing. But first, the respondent number one will have to submit.
yes,
So, Union of India is later. Yes.
First, they're continuing.
3rd August, Malad, 3 p.m. Your Lordship.
Yes.
I'm grateful.
Deeply obliged, Your Lordship.
That's in item number 3, my lord. I'm for the petitioner. But before I start, my lord, I must be candid before my lord. This matter was inadvertently mentioned on the last occasion. And that is why, your lord, and number 4, that ought to have been mentioned ideally. That is why your lordship had indicated on the last
So which
occasion.
matter is to be heard? 3 or 4?
Lord, in
3 and 4 are different matter.
That's
They're
why.
different matters, my lord. My lord,
He has mentioned the matter.
Lord,
So,
we
that
did
too
not
without
mention-
notice.
Lord, we did not mention some other counsel probably appearing for number 4. He erroneously gave our number.
No, which is erroneously?
Our
Number
matter
4 or
has
number
been
3?
erroneously. My lord, number 3
You are
has-
appearing for?
Lord, I am appearing from respondent number 1
Which matter?
in item 3.
Item 3 is inadvertently.
inadvertently, my lord.
Okay.
You don't want to move it.
No.
Because we
Record or not.
But my lord, since it has appeared, my lord, any day subject to your lordship's convenience, it may be fixed, my lord, so that this can be heard out.
Record and order. Learned counsel for the petition submit that inadvertently the matter was mentioned before this court and this court has fixed the matter today at 3:45 p.m. Accordingly, he prays for fixing another date. Let the matter appear 30th June, July at 3:45 p.m.
Grateful, my lord.
Yes, next 4.
Item number 4. Your Lordship, I am appearing on behalf of 3 and 4 SEBI.
Who is for the petitioner?
Mr. Vishwarup Bhattacharya is appearing in this matter. He is engaged in courtroom number
Who?
18. Mr. Vishwarup Bhattacharya.
Suru Bhattacharya.
I am
Yes.
playing for short possible, Lordship.
What is the matter?
Lordship, I am not engaged in this matter. I
Not engaged.
Lordship,
Defreeze.
Your Lordship, if I may, I'm appearing on behalf of SEBI. Your Lordship, before I
You are
start the
appearing for?
SEBI 3 and 4, Your Lordship.
Ah.
Your Lordship, the matter was mentioned, no notice was given. Irrespective, Your Lordship, if Your Lordship can come to the prayer portion once, Your Lordship. It is at page number, Your Lordship, internal page 21, Your Lordship. I'll just read out 2 prayers to Your Lordship. Rule 26 of the rules of this Honorable Court relating. I'll come to straight to prayer B portion, Your Lordship. A writ in the nature of mandamus directing the respondent to remove the debit-free status of your petitioner's saving bank account, being account number so-and-so with Punjab National Bank, and saving bank account being account number so-and-so HDFC. Your Lordship, now prayer C, Your Lordship. A writ in the nature of certiorari do quashing any orders or directions issued by the respondent. Nothing has been specified, Your Lordship. Third, a writ in the nature of certiorari calling upon the respondent to transmit all case record before this court. And then there are general prayers, Your Lordship, which I'm not getting into.
Yes.
Your Lordship, they have not mentioned against which order they have preferred this writ petition. And before I get into the merits also, I'm not getting into the merits because my learned friend is not here. But what I want to point out, Your Lordship, there were total 3 proceedings initiated against this petitioner, this writ petitioner, Your Lordship. The writ petitioner has gone to SAT. The matter was fully heard, adjudicated upon, and order was passed by the SAT dismissing his appeal in 2018. Now in 2026, he is re-agitating the same issues, Your Lordship, which has already been decided by the SAT authority. Just to give you a very brief background, the orders he has not placed on record, Your Lordship, the SAT orders.
Yes.
So the SAT orders has not been placed on record. But for your Lordship's reference, I want to refer to this list of date. Very basic. I'll hand it over to my senior friend as well. And few orders.
Is there suppression?
Nah.
We are not suppression. We are just pointing out a very brief background to your Lordship about that how the orders have been adjudicated upon by the SAT.
Yes, let the petition complete.
Yes, Your Lordship. Yes, Your Lordship.
The issue is, only the person concerned who is before your lordship, he happened to be an executive director of a company, which is subsequent to his resignation. He was an executive director. He was in no way connected with any financial affairs of the company. That may be a usual defense according to your lordship and according to SEBI. But the fact
I am not
no, it may be. It may be construed, that is a usual defense and I am no way connected. But the fact remains, he was there till 2013. This entire proceeding, whatever has been initiated is post 2013 and alleging his complicity into whatever affairs that the company did during a substantial period of time prior to 2013 or even post 2013. The proceedings triggered, ultimately it gave way to certain orders which was carried in appeal. Ultimately, the factual position today is this is my affidavit of service. The criminal proceeding, a trial is going on before the Bankshal court. I had carried a revision from one of the orders, the revision failed. I am indicating to your lordship in insofar as, exonerating me.
What is the section?
Under the relevant provisions of the SEBI Act. Specifically, it is nothing, my complicity is not there from their own findings. The main person who is responsible is one Mr. Duraji or Dujari, who was the main person of this company, whose role is primary. Now, what I want to today, the immediate problem is, I have post my resignation, I worked in some other company. I have my savings, my retirement benefits, retirement dues, those accounts have been frozen. I have prayed for defreezing those accounts. I have written to them by way of representations.
Who has frozen the
SEBI. In terms of orders, not SEBI. I won't say SEBI has done it. After the intervention of the this appellate authority and the other authorities of SEBI under relevant provisions of the Act. I want this defreezing. Now, if they want to, today two things can happen. First of all, this defreezing did not take place yesterday. It took place quite some time ago. It's of 2024. My last representation also appears to be of 2024. I can only beseech and beg before your lordship that if they come with some report, some response to the writ petition or to my plea regarding this defreezing the account or what they want to do, because if they say, because the finding is that I am not in any way connected apart from my role being a director or an executive director.
No, if there is an order of the concerned forum or the appellate authority,
yes,
and on acting on that, the bank has freezed your account.
Yes, on the basis of those orders.
What the writ court will do now?
The writ court is being we are approaching your lordship for two major reasons. First is for defreezing these accounts upon intervention, upon going through the various orders and various facts and figures. That is one aspect of the matter. The other way it can be looked into is if they say that I am the key person, I am the key player, and I had total role, then that case has to be run by SEBI. They have not run their case even before the authorities, before the SEBI authorities or the appellate authority, whoever. Now, that case was never run. Their point was Mr. Dujari. I was a part of the company as an executive director and my role was also limited. It is not that my role was an exemplary this involvement insofar as every affair of the company, even running into this whatever misdemeanor has been alleged to have been committed by the company or by Mr. Dujari. I was not instrumental. I was not even a participant to it. But as an executive director, I have been intercepted. And that is my only role.
So no, that's why. If
today
there is an order of the authority and the appellate authority, how?
I was only beseeching your lordship. If today, the matter may be posted for some other day. If today they can come or they, if subject to your lordship permitting, if I may most humbly pray that if the SEBI authorities return with some sort of a response so that we come thoroughly prepared and the matter is put to response for all.
Yes.
That is I leave for your lordship's discretion, but there is no requirement for, this is what I see, for exchange of affidavits or any kind of report. First of all, my learned senior friend got the matter fixed for today. So we are here with all the relevant documents, and I just want to point out to one document to your lordship. And if your lordship still feels there is a requirement for filing a report, very well, we do so, your lordship. Just one order we want to place it on record. It does not form the part of the writ petition. So I'm just handing it to your lordship and even to your.
May I look into it and come back?
Sure, sure. I will just point out one thing.
Please. It is concerning this company.
And this say the appeal has been filed by the same writ petition, your lordship. I'll just point out two paragraphs.
আমাদের কপি নেই মানে জজ সাহেবকে দিয়ে দিলে তোমার কপিটাও তো থাকবে আমারটাও নাই ছাড়বে
Your lordship, I'll just point out two paragraphs. The relevant page is page number 3, your lordship. Just two paragraphs, your lordship. Para 4 first, if I may read out. Counsel for the appellant is the writ petition.
Yes.
Counsel for the appellant submitted that the impugned order is unsustainable. The impugned order defeats all those orders, the recovery proceedings against which this writ petition has also been filed. Firstly, the appellant was not a director of Amrit project, the subject company, and was appointed as a director of Amrit Bioenergy and Industries Limited for development and building up a green power project in West Bengal and Assam. Since the appellant is not a director of Amrit project, the WTF SEBI is not justified in treating the appellant as a director of Amrit project and accordingly issue direction against the appellant. Now, your lordship, I'm coming to paragraph 6. First contention of the appellant that he was not a director in Amrit Project Limited is falsified by the written complaint filed by the appellant on 6th June 2017 to the officer in charge, Beniapur Police Station, copy of which is annexed by the appellant itself to the memo of appeal at page 105. In the said letter, the appellant has categorically stated that he had joined Amrit Project Limited as an employee in the year 2004, and later on the appellant became one of the directors of the company. Thus, the very same document relied upon by the appellant falsified the case of the appellant that he was not a director of Amrit Project Limited. Accordingly, the first contention is without any merit. Now, your lordship, the second page, para 7. Second contention raised on behalf of the appellant is that as per the order passed by this honorable court in company petition so and so, the chairman and managing director of the company has agreed to take the entire responsibility to disburse the amount due to the investors, and therefore the liability fastened on the appellant does not survive. There is no merit in this contention because the Calcutta High Court in the aforesaid company petition has neither considered nor modified the impugned order passed by the WTM of SEBI. Since the direction given in the order to refund the amount is joint and several, if the chairman and the managing director of the company discharges the entire liability, then obviously the appellant cannot be called upon to discharge the liability. However, the fact that the managing director has agreed to discharge the liability cannot be a ground to exonerate the appellant who, in spite of being a director of the company, has been falsely claiming that he was not the director of the company. In such circumstances, both the appeals are dismissed with court quantified to 25,000 in each matter, total rupees 50,000 to be paid to appellant to SEBI within 8 weeks. This is a 2018, your lordship. And after this order, your lordship, the accounts were frozen. So there were total 3 recovery proceedings initiated against the writ petition. The first 2 were of dated 23rd February 2016 and 26th February 2016. And your lordship, against this, he challenged it and came before the SAT. The order was there. He did not challenge the writ. Then against those orders for the compliance, we have freezed this bank account as per the procedure laid down by the SEBI guidelines. Now, your lordship, there was another recovery proceeding which happened in 2020. But he has mentioned it over here in his writ petition, but it was not challenged, your lordship. So there were total 3 proceedings, your lordship. Now in 2026, he is before this court, invoking the inherent jurisdiction, re-agitating the issues which has already been decided by the SAT authority. He is not challenging the SAT order. He is challenging the recovery proceeding order. So this is not that he is here challenging this order. So the recovery proceeding order has already been well decided, Your Lordship. Now, if Your Lordship,
Where is that order?
Your Lordship, the order which we have handed to the
Other than this order?
Your Lordship, this is the two recovery proceedings which he has challenged,
Okay.
and his appeal got dismissed. Your Lordship.
Where is the recovery proceeding order?
Recovery proceeding order, yes, Your Lordship. I'll just show you.
Annexure P5, if I am not mistaken, page 68.
Yes, Your Lordship. It is only one order he has annexed 26th February 2016. P5, I will just indicate from where he came to. The Lordship comes to
No,
page
81, 97. 81 is another one.
the relevant one from which he came to.
SAT.
97.
7.
Yes.
Order would challenge the Lordship before the SAT, and from this order, his accounts have been frozen, Your Lordship.
Okay. Yes, Mr. Bhattacharya.
I need to have a.
Any further?
Yes, Your Lordship, just one more paragraph which I wanted to point out to you, just one last paragraph. One finding. Lordship, if Your Lordship come to page 42 once, Your Lordship. Order starts from page 41, Your Lordship. This is another recovery proceeding which happened against him in 2020, Your Lordship. I just want to.
Page?
42, I just read the first few lines, Your Lordship.
40?
42.
Yes.
Your Lordship, if Your Lordship can come to the second line, farm bond is found to have been issued at least 830 investors in the financial year 2007-8 to 2012-2013, and thereby raised the sum of 98 crore 78 lakh. Further, infra bonds were found to have been issued so and so, Your Lordship. Now, if Your Lordship comes to the relevant portion, further infra bonds were found, Your Lordship. This entire paragraph indicates that what kind of legality which has happened, which led to 3 recovery proceedings against the writ petitioner and the company, Your Lordship. Just to indicate that, Your Lordship.
Yes.
His contention that he was not a director is not correct, Your Lordship. This order clarifies and states very well that he was the director throughout. Even
Yes.
after 2020, he was the director. And that has been held in 2018.
Okay. That's all? Anything
I'll go
further?
to this mail and I'll respond tomorrow. Kindly keeps it tomorrow, I'll respond tomorrow.
Your Lordship,
Just give me your days, just to go
Your
through this
Lordship,
last order.
if you can have, Your Lordship, day after tomorrow.
No, I don't have.
Learned counsel for the respondent. Counsel for the parties have argued the matter at length. Also counsel for the parties suppressed for recommendation. According case is adjourned. Let the matter appear on 2nd July.
Your Lordship,
2nd
I'm
July.
so sorry, Your Lordship. If it can be third, I'm so sorry, Your Lordship.
Third
is
already fixed. Third
Friday.
already fixed.
Third is different.
Fourth you want? 7th.
7th. Very good. Okay.
I get the week. No, I have a bad case to run, but definitely, I can try. To try is
All the advocates will not win all cases, and good advocates are losing the matters. Bad case coming to the good advocates.
a case is a case. That is what we have learned from your Lordship.
Number 5.
Well, item 5, my lord, I appear for the petitioner. But if your lordship sees the last direction, that we were to serve a copy on State Bank of India. And now they are appearing, my lord, my affidavit of service is on record.
What? What is the matter?
Yes, my lord, the instant petition, my lord, arises out of, my lord, the arbitrary act on the part of the bank, my lord, in the context of a fact that I had availed loans from the bank. The loans were obtained, my lord, prior to, my lord, 2025. There were talks of settlement in between the banks. We had ultimately, my lord, arrived at a understanding that we will settle the loan account by paying a particular amount of money. Now, my lord, in order to enable and enforce that particular agreement, we were called upon to deposit, make an advance deposit, with the condition that prior to, on making these deposits, there will be further talks that will be conducted between the parties, and finally the terms of settlements would be executed.
Correct.
On the strength of such an understanding, and there's a specific document on record, which is at page 23, we deposit 27 lakhs. Subsequent to the deposit being made, and at the time of deposit, the understanding was that the settlement between the parties would be at 2.75 crores. After I deposit, there is a proposal which comes from the bank that you have to enhance the amount. We will not give effect to the terms of settlement. We agree to that as well. Thereafter, my lord, there was an agreement to enhance the offer to 2.80 crores. My lord, we agree to that. On the strength of such an agreement, there was a sanction letter issued in our favor. Now, the sanction letter, my lord, stipulated that on or before March 27th, we will have to pay the balance amount, but considering that we have already deposited 27.5 lakhs. My lord, on 25th of March, I write a letter to the bank requesting them that give me 2 days time. Instead of 27th, I will deposit the entire amount on 29th. My lord, what they do is quite startling. They, my lord, I'll indicate, show from the documents also, because all this is, my lord, speaking from the records. Instead of, my lord, understanding my request, my lord, they straight away, my lord, go and cancel my lord, the settlement letter which was executed in my favor, and they appropriate the entire sum of money. My lord, the agreement was that I deposited on the strength of an understanding that there will be a settlement which will be arrived at a subsequent stage.
There's no settlement entered into agreement entered between the parties.
Yes, my lord, there was. There was. But there was a qualification to that, my lord, which I wanted to show. But the
writ petition.
But the writ petition is, my lord, on the act of the part of the respondent bank. My lord, in
The bank, how the writ petition?
That will kindly comes to page 23 once. 2 documents I'll show, my lord. Kindly comes to page 23. There was a specific understanding that in the event, Lord, kindly sees as per the authority letter so and so, we have transferred so and so to our
Page 33.
23.
23.
Annexure P4.
You are advised to deposit remaining amount.
In case compromise proposal rejected by the bank, this token amount for settlement will be refunded to you. Lord, I am only relying, my lord, my sole reliance is on this particular letter. Now, subsequently, Lord, the sanction letter is at page 31. But the sanction letter is at page 31. It says, my lord, that the total amount under the settlement will be 2.80 crores. Clause C, the balance amount has to be deposited by 27th of March. Clause C. Lord, I make a request on the same date, my lord, at page 33, annexure P10.
How much amount you have paid?
But I paid the advance amount.
What?
My lord, that 27.5.
24,98,000.
27.50 lakhs. At page 23, which I indicate.
23, 24,98,000 from your account. And no lien account.
The bank statement is at page 27. My lord, I've indicated that I've paid 27.50 lakhs, and that is also in fact been recorded in the letter dated 24th of March 2025. Now, on the same date, my lord, I make a request that instead of 27th, kindly grants me extension.
But you kindly come to then why E? Kindly come to the E page 31. Consent term with default clause will be filed before the presiding officer. DRT.
Yes.
Then you could have been make an application before
My
the
lord, my case today is that the bank, despite there being an understanding that I am making a payment, my lord, this is not earnest money, it's an advanced money. The contract is to be executed in the future. In the event there is an understanding that in the event the compromise do not work out, they are liable to, my lord, refund the entire money to me. Lord, I do not have an option today, my lord, to go before the DRT, because right before this agreement could have been placed into effect, my lord, they had already cancelled, my lord, the entire sanction letter. Lord, that cancellation, your lordships will find at page 41 on 3rd of April 2025. So, my lord, there was no opportunity for any of the parties, my lord, to go before the presiding officer to make an appropriate prayer, my lord, to arrive at a consent decree. And there is a specific admission that in the event the settlement do not work out, the money has to be refunded back to me. And the money was paid into...
Yes. You entered into settlement, that is first compromise offer is 22nd January 2025.
Yes.
Correct.
Yes.
Then subsequently in March 2025, this letter.
Yes.
This letter provides the consent terms of the default clause if filed before. So after this letter, you have deposited already the amount. So you could have been filed an application for the DRT, the bank. The DRT would have been issued the notice to the bank. Then matter ends.
But this, in my respectful submission, my lord, this particular letter, my lord, had no correlation, my lord, insofar as the proceedings before the DRT is concerned. The amount was placed, my lord, the advance money was deposited, my lord, way back in January. And this letter came into effect in March 2020.
Correct. Correct. Then?
So, my lord, in my respectful submission today,
so what you want?
Today this money has to be refunded back to me, my lord. Three legal contentions, my lord. One is that the money was specifically put into a no lien account. No general lien could have been exercised because this was not an understanding, my lord, or not a contract, or where a lien was my lord, created in the ordinary course of business. It's a special circumstances under the garb of a settlement which they have, my lord, agreed between the parties. Second is, my lord, I'll rely on a decision that in a situation like this, my lord, it is the utmost responsibility of a bank, being a nationalized bank, State Bank of India, to act fairly, my lord, which is that amounts, in my respectful submission, violation of Article 14 and 19. And number three is that this money was advanced with an understanding that it will be paid as an advance money. So there's a distinction. I'll place another decision. There's a distinction between advance money, earnest money. But earnest money, if this money was accepted as an earnest money, that would have, my lord, entitled to a situation.
Under which circumstances the settlement has come between settlement ended between the parties?
Under the circumstances of the letter in March.
You are the borrower.
I'm the borrower.
Correct.
Yes.
There was a due.
Yes.
So you have to pay the amount.
But for that, I'm already facing separate proceedings, my lord.
What proceedings?
My lord, they have, my lord, initiated DRT proceedings against me, my lord. My secured assets are with them.
That's what I'm telling. They have initiated the DRT proceeding. Then you could have been filed the interlocutory application before the DRT proceeding.
But in my lord, this particular money, my lord, again was, my lord, we had deposited, my lord, under an independent contract. My lord, it had nothing to do with the DRT proceedings.
So how that's why I'm asking. If it is an independent, why you are given the all the persons are taking the loan from the bank and you are going the money to the bank? It is a settlement with regard to the loan amount only. So how you can say this is
the settlement never, the settlement never came in. That's my submission. The letter.
You before the page 41, before page 31, that is the letter dated for 24th of March 2025. You have deposited 24 lakhs. Kindly come the page 23.
Prior to that, prior to this,
That-
yes.
Correct. On the basis of the compromise of your NPA account, and you have paid. Subsequently, to March, the compromise entered between the settlement offer letter has been given to you. Offer letter has given to you.
This was conditional. This was conditional that we are giving you a window. You please deposit the balance amount. Otherwise, the settlement fails, and I will have to face the brunt of the DRT proceeding,
Correct.
which I am already facing, my lord. Today
Correct.
they are proceeding against me before the DRT.
Correct.
But so far as this understanding that the money which I am putting into, my lord, the advance money which I had put in, my lord, that was, my lord.
How the writ court can do that? You go for the recovery.
But
you go for the recovery, file the money is
Sir, will
to
kind-
the bank, recovery amount. How the writ court can say, no, you have to pay the amount
But
settlement?
the
We don't know.
ex facie the document shows, my lord, this
Ex facie
does not
might
requires an
be.
intrinsic, my lord, evidence into the matter. The document shows, my lord, will kindly just one sees page, my lord, 23, annexure P4. Lord, their letter, my lord, this is not something which we have coerced them in, my lord, issuing it.
Correct.
They lied that in case the compromise is rejected by this bank, which they have, my lord, by the letter dated 3rd of April, the token amount for settlement will be refunded to you.
Correct.
So this was an, my lord, at max an undertaking or an understanding that yes, this amount is being accepted in order to give effect to a settlement, in order to give effect to a contract, my lord, which ultimately, my lord, did not come into force. So, my lord, if your lordship sees my prayer, my lord, my prayer is only one fold, is that being a nationalized bank, Lord, considering, my lord, it comes within the purview of, my lord, Article 12, my lord, they have to, my lord, also bear a responsibility, my lord, to act fairly towards all its customers, my lord, which it has not done. Lord, the documents itself shows, my lord. Lord, in reliance of it, my lord, may I just show one decision, my lord. Karnataka.
Yes.
Lord, will kindly cease, my lord, this is 2022 SCC Online, Karnataka 1862.
Yes.
Will kindly cease, my lord, paragraph 18. My lord, paragraph 12, my lord. At page 10. The learned counsel appearing for the respondent will
Page?
Lord, internal
Paragraph?
Paragraph 12, page 10, paragraph 12.
Yes.
But first is the contention noted by the respondent's bank. My lord, I'm reading from the 5th line, these submissions. In the peculiar facts of this case is unacceptable. It is not in dispute that the bank is a state under Article 12 of the Constitution of India. Even in a commercial transaction of this kind, it has the duty to act fairly. It is not in dispute that the petitioner had deposited 18.90 crores by selling his property, and the bank retains 18.90 crores and proceeds to auction other properties of the petitioner on the ground that the loan is not cleared. It would have been a circumstances altogether different if the petitioner had defaulted in OTS before the deadline that was stipulated by the bank on the agreed terms and conditions, which was on 28th of February. The petitioner had deposited so and so crores, and later on 26th of March 2021 deposited 52 lakhs. All these amounts are accepted by the bank. In one breath, the amount is accepted, and in the other, surfacey proceedings are instituted by cancelling the OTS. If the bank had cancelled the OTS, it could not have retained the amount paid under the OTS and put the property of the petitioner to sell as well. The action of the bank do not behove with status of being a state under Article 12 of the Constitution of India. But may I just read the first 5 lines I should have read from the submissions. The learned senior counsel appearing for the respondent would submit that the amount was not paid in full, interest had to be paid, and therefore exercising liberty that it had reserved to itself while offering OTS, the OTS comes to be cancelled. No fault can be found with the said action. The submissions in the peculiar facts, thereafter I read. But in my case also, if your lordship sees, the money I had put in, in order to give effect to a terms of settlement. And it was conditional, where the bank themselves have given an undertaking by a letter that in the event the settlement ultimately do not work out, we will refund you back the entire amount. And ultimately the settlement did not work out. And I'm facing, my lord, DRT proceedings, my lord. Of course, my lord, whatever the law will permit, my lord, I'll have to face the consequences. My lord, that will have no impact, my lord, in so far as my claim in this particular amount is concerned. And I'm relying on a specific document that has been issued by the bank, not a disputed fact. This is a letter, in my respectful submission, cannot be disputed by the respondent bank. But next, just to, my lord, show the difference between the earnest money and advance money, my lord, may I just rely on one Supreme Court decision?
That is not the case. It is not the case, the earnest money. Yes, what is your case?
My lord, I have 2-3 points, my lord.
Yes.
Firstly, my lord, this court does not have a jurisdiction because everything was entered into, all transactions made in Delhi. Delhi court will have jurisdiction. State Bank of India, Calcutta does not have any jurisdiction. My lord, if your lordship takes a cause title of the petition, my lord, State Bank of India, respond number 1, my lord, here they does not have any correspondence with this branch. State Bank may be having branch in Calcutta, but that does not mean this court will have the jurisdiction.
Now, where he has
Everything in Delhi.
Where he has deposited the amount?
In Delhi, everything in Delhi.
This page 23.
My lord, Delhi, all correspondence from Delhi.
Taliganj?
Lordship, my lord, it is, his address is Taliganj. State Bank of India, Delhi. My lord, the second issue is, my lord, he knows very well this account has been assigned to Kotak Mahindra Bank. Lord, he has suppressed that. Lord, may I just show to your lordship the letter that was issued to him?
May I just say one thing? I did
My
not
lord,
want
thereafter, my lord, he has proceeded.
I have not suppressed. On the last date, I have come and made a submission that while this proceeding was pending, we have received an intimation that this loan has possibly been assigned to Kotak
Then
Mahindra
Kotak
Bank.
Mahindra should have
But
come in.
still, still my claim is against State Bank of India.
Okay.
So if your lordship directs State Bank of India to be present, my lord,
Lord,
on the
cannot.
strength of
Lord, we have
my
already
submission, your lordships had, my lord, directed us to, my lord, once again serve State Bank of India, which we have done. So there is no question of suppression, my lord, in this case.
My lord, now thereafter, my lord, he had approached the London Mediation Center for settling the loan account. My lord, he is proceeding under the SARFAESI Act. My lord, SARFAESI proceedings were dismissed. SF proceedings dismissed. My lord, he knows that in mediation, the Kotak Mahindra Bank is a party. My lord, he had addressed a letter to the Kotak Mahindra
What
also.
happened to the mediation?
So that is pending. That is, I think, date has been given.
Mediation pending. What? Why you filed the writ petition here?
My lord, my case before the, my lord, before this honorable court is, my lord, restricted to that money which I had advanced.
What is the case before the mediation?
Lord, my on instructions, I'm submitting this, my lord. We have a claim for damages against the bank. So on context of that, there's a pre-suit mediation proceeding which is going on there.
Damages you
Well,
got.
until unless
that has nothing to do with,
Lord, I cannot
my lord,
say
what
anything.
is there,
And my
the
name may be
claims that I
deleted.
have before your lordships today.
No.
No jurisdiction in this court, my lord.
What do you want?
But Lord, I relied on this letter, my lord. This letter is a self-speaking document, my lord.
Relied, it's okay. How in the writ court, all the things, if you paid and the OTS has been.
My lord, even he knows that, my lord, under OTS, the OTS has been cancelled. My lord, thereafter, we have taken physical possession, recovery proceedings going in Delhi. He is well aware of everything.
Lord,
Suppressive proceedings dismissed, he filed an appeal dismissed,
I just
he
come
filed
and
review.
try to
That is still
satisfy your
pending.
lordships, my lord.
Purpose should be so. You tell me so.
Lord, this is not in a strict sense. My lord, I understand, my lord, what's falling from your lordships, that money recovery case, why should the writ court interfere? My lord, possibly
Not
this
writ
would be
court,
one of
not the money should see. This
one
is
of
a
the
bank.
exceptions, my lord, in which your lordship may exercise discretion.
This correct, but here you are the borrower, you obtain the loan, subsequent NPA, your account has been declared NPA, then you went to the bank for compromise, some amount has been deposited, then further condition has not been fulfilled, then it was been recalled, now you wanted in terms of this, the amount is to be returned back, but other proceedings are pending. Other proceedings are pending. If today sitting in the jurisdiction will pass an order, yes, in terms of this only 2-line conditions, so you deposit, return the amount, how the bank can, this court can justify by passing that order? How the court can justify by passing an order for refund of this amount to you? So the other proceedings are pending and this amount has already been given to the Kotak Mahindra.
Kotak Mahindra, Lordship.
Then
Even Kotak Mahindra is not a party to the writ.
and Kotak Mahindra is not a party, then what
But,
can?
but may I, my lord, make one humble prayer? May I just consider this pending proceedings, and thereafter, my lord, my lord, request your lordships to consider, and my lord, whatever order.
My name
shall
will
have
be
to
declared in Kotak Mahindra.
That cannot be, my lord. Ultimately, he accepted the money. Anyways.
Now everything has.
Counsel for the petitioner has argued the matter at length. Full stop. Land counsel for the respondent bank raised objection with regard to the maintenance of the writ application. Full stop. Counsel for the petitioner prays for time to take instruction. According cases adjourned. Let the matter appear on 21st July.
No, in the meantime, let him take steps for deletion of my. In the meantime, let him take steps for deletion of my name.
Come on, there will dispose.
Lordship. On the merits, my lord, I cannot say what has happened thereafter in the Kotak Mahindra, whether they have an.
That's why let me come on.
Lordship.
Grateful.